Your Lordship's limit.
Was not approved by the respondent. Now they have already taken for the we are not able to
Tax matters, two matters. For a deemed capacity, they are demanding the tax, they are not issuing NOC. Tomorrow,
Lordship, tax matter as well. 10 crores has been taken away from the petitioner without issuing any order and everything. It's been lying for one year.
Your Lordship.
18th May. 18th.
Your Lordship.
No, the 23 matter listed on next Tuesday when the tax matter comes. 18.
Your Lordship, this is a fresh matter. Your Lordship.
Obligation.
Tax matters, so the both are given chief my lord, will be listed on 19.
tax matters, the fund does not file even after 1 year.
Your Lordship.
The matter has been listed today, number 77. There are certain annexes to be changed, so I request you to give the petition. We have filed the wrong assessment here, form 26 and 3.
This case was posted, direct to be posted today, my lords, but not been done. There is a stay of the 148 notice, but in the meantime, the assessment order and the penalty notice has been issued. My lords. Department has issued a show cause notice. Yesterday also I moved, so directed to be posted today, not been done. Tomorrow, kindly. My lords.
Your Lordship, this is an education matter, my lord. This matter is a day after tomorrow. Yesterday, my lord, the matter is listed. But that day, caveat copy is already served and they are appeared before this court. And that day, adjourn the matter and direction was issued. Lordship, list the preliminary hearing. Yesterday also, this matter is came before court and that is matter serial number 50. Yesterday not reached, my lord. This is matter, they are taken the 24th. The day is given to 24th, my lord, but urgency is there. ಇಲ್ಲ ಇದರಲ್ಲಿ urgency ಏನಂದ್ರೆ Lordship tomorrow, my lord, urgency.
My lords, this is a tax matter where there is a recovery notice issued and there's a threat for recovering it from the bank. Today, 2:30, is it possible?
Adjournments list 1, page number 1, 1 to 5. Page number 2, 19, serial number 6 to 2012, 6 to 12. Page number 3, 13 to 18. Page number 4, 19 to 26. Page number 5, serial numbers 27 to 34. Page number 6, 35 to 41.
Serial number 40.
40. Yes. Inform the other side.
I'm for the petition. my lords.
Week after next date request. Yes.
Page number 7, 42 to 46. Page number 8, 46. Page number 9, 47 to 49. Page number 10, 50 to 55. Page number 11, 56 to 61. Page number 12, 62 to 65. 61.
6.
61.
You have informed the other side. At request, relist the matter on
25. Page number 12, 62 to 65. 13, 66 to 70. Page number 14, 71 to 75. Page number
74, my lord.
74.
yes.
Appear for respondent, my lord. I pray for 3 weeks time, my lord. The pleadings has to be completed and department is likely to
74.
engage ASD, my lord. I
Yes.
require some time, my lord.
You have informed the other side.
No, my lord.
74.
They want an adjournment in order to file their statement of objections.
Appearing.
The pleadings must be,
Lordship, there is no urgency, there is already stay, my lord, and
let them complete their pleadings. Let them complete their pleading. We can't take it up finally without their pleadings on record. We'll fix a date. Statement of objections to be filed by the next date. Relist the matter
after 3 weeks, my lord.
after 3 weeks date could.
3rd July.
Let them,
37. 37.
No, no, if there's any further interim relief, I keep it open for you to move. Yes,
Page number 15, 76 to 79. Page number 16, 80 to 85. 17, 86 to 88. List to 2, page number 1, 1 to 4. Page number 2, 5 to 9. Page number 3, 9 and 10. 10 and 11.
One submission, my lord. My lord, the petitioner is the engineering student, my lord. Is studying in 8th semester, my lord. One exam, they are not permitted him to take the one exam of the 8th semester, my lord. The rest of the exams of the 8th semester is written last year, my lord. It is scheduled to be held 2:30, my lord. It is-
2:30.
Yes, my- it is, exams are scheduled to be held from 18th, my lord.
Let it come tomorrow. That is tomorrow. But I will not grant ex parte interim orders unless the other side is there. So you intimate the other side in advance.
Yes, my lord.
Shortage of attendance, no interim order. Yes.
Okay, yes,
List 1, preliminary matter, serial number 1. Pradyumna.
Yes, commercial tax.
74 lakhs.
Yes.
Lordship, bring for quashing for show cause notice is a manufacturer of pharmaceutical products, Lordship, anti-cancer drugs. So what he does is he utilizes all inputs, Lordship. The resultant final products are manufactured. He's got an effluent treatment plant within the factory, Lordship, where the effluents are first stored. Some effluents are so hazardous, Lordship, they have to be disposed of in a scientific manner in accordance with the provisions of the Pollution Control Board, Lordship. They are taken in trucks by Bangalore Biotech Private Limited, which is a specialized company in disposal of solid waste, that to hazardous, Lordship. They're taken, once they're disposed of, he issues an invoice in the name of the petitioner, Lordship, for carrying out this activity.
But this is only show cause notice.
Show cause notice, by bring for quashing it, Lordship.
What you are raising are mixed question. It's a question of fact and appreciation of facts.
It's it's actually a question of law, Your Lordship. Totally incorrect, Lordship. Lordship, may kindly see 17H, Lordship, definition citing.
To
which-
make out a reply, it's no cause for interference at show cause.
Lordship, ab initio, Lordship, may kindly hear me out for a minute, Your Lordship.
Yes,
Lordship, the amount is proposed as, it is contained by the department as block credit, Your Lordship. Block credit, Your Lordship, may kindly see section 17(5)H of the GST Act.
yes.
Section 17, subsection 5H, Your Lordship.
Of
The GST Act, Central GST Act, Your Lordship. Central Goods and Services Tax. Section 17, Your Lordship, pertains to blocked credit which cannot be availed at all by anybody, Your Lordship. Subsection 5, Your Lordship, clause H.
So this is only in so far as goods lost, stolen.
Goods
destroyed.
lost, stolen, destroyed, written off, or disposed of by way of gift or free sample system, not at all covered, Your Lordship. This is a service, Your Lordship. Doesn't fit into the definition at all. Goods lost, stolen, destroyed, written off, or disposed of by way of gift or free samples. No way connected, Your Lordship. It is only a service, whatever I will credit. Those proceedings themselves are totally vexatious, Your Lordship. And in fact, the petitioner's records were audited for a previous period from 1718 to 2019, 2021, Lordships. 1718 to 2021. This issue is not at all taken by the regular audit. Audit reports are placed in the petition. There was never any objection. Now suddenly enforcement comes and says this is the blocked credit. And in no way related, I have not availed any credit on goods, Lordship. What I have availed is credit on services.
Take us to the show cause notice. What
Please.
is the ground made out?
Please. Lordship, may kindly come to page number 24 onwards. Page number 29 is the precise paragraph, Your Lordship. Page number 29.
Yes.
The last button para, Lordship, which I will read with Lordship permission. The plain reading of section 17.5H clearly indicates that ITC on the inward supply received by the recipient towards destruction of hazardous waste is not eligible. Therefore, the ITC claimed on the inward supply of Messrs. Bangalore Eco Park Private Limited for the tax periods 1920 to 22-23 are proposed to be demanded in this DRC 01 notice. That is the DRC 01. So that
No, what do you mean by destroyed is a matter that has to be decided after hearing? Here again is your.
again, same which are contained in Lordship in another petition which are filed challenging issue cause there, the order has also been passed. Overlooking my reply, another petition. Order has been passed confirming demand, Lordship.
But then you will have to make out a reply. What is the?
Lordship,
What
I
is
have
the-
made the reply. Our reply is there, Lordship.
No, no,
I
what-
have filed
Correct,
the reply.
it
Lordship.
has to go through adjudication. What is?
Same
the-
process because it's a fait accompli, Lordship. Lordship, may kindly see page number 31. My reply is there.
What is destroyed is a matter to be appreciated.
It
in
is
what-
there, Your Lordship. In fact, page number 31, Your Lordship, may kindly see. I have given the reply. In spite of my reply, the show cause notice have been issued.
No, correct. What is the connotation of the word destroyed? Whether willfully
Destroyed, no, Your Lordship.
willfully destroyed or destroyed otherwise is a matter to be interpreted. That we
Lordship,
cannot decide. in-
I'll make a submission. Destroyed are goods, Your Lordship, where before use they're destroyed. The goods are lost by way of accident or natural causes. Destroyed before use utilization, Your Lordship.
That we don't know.
That is the provision, Lordship. That is a provision.
That we don't know.
Why all praise, Lordship. For the time being, an interim relief may be granted, Lordship, because that another issue is also coming up before Lordships, where my reply has been not been considered and order has been passed. Identical, overlooking my reply. This is the case, Your Lordship.
What is-
It's only a show cause notice, Melissa, and that is dated 29/11/2023. So I don't know whether it is already culminated.
It's not passed. It's not passed. Otherwise, I would have.
Coming up for the first time.
Yes.
But anyway, they can show cause to this, Melissa. Matter can be adjudicated before the adjudicating authority.
To undergo the adjudication process itself, Lordship, again the same, because in another matter it's happened already.
That's a different matter. It has to come up only.
Now,
in
I
the-
only pray Lordship an interim relief now, that another petition will also come before Lordship. After that, it can be taken, Lordship. Because I fear that will be adjudicated in the same manner, Lordship.
No, no, you adjudicate. That is a different matter.
For up to a week, Your Lordship, because I may, if it is, I will also question, I will examine whether it is already been order has been passed, that also confirm.
I'll have it next week. You take a call. I'm not inclined to grant interim.
Before that, Your Lordship, that petition I will present with the liberty to another petition where order has also been passed.
No, that we'll see, but I'm saying no case for interference at this stage.
Because it's ab initio, why, Your Lordship, totally.
No, we don't agree with you. The word destroyed, we don't know what.
Destroyed, my learned friend may comment on that, Your Lordship, whether destroy means.
Actual position.
No, destroyed is for something which is prior to my utilization, Lordship. Otherwise, destroyed, this is utilized for production of final product, Lordship. The inputs are used.
If the interpretation of the word destroyed requires so much of arguments, then might as well make
That-
out a
that
reply
can-
into
that-
the show cause.
What a prayer, Lordship, that can be seen final, Lordship. In the meantime, I stay on the show cause notice, Lordship.
No, no, you participate,
Because he will adjudicate
you participate in the adjudication process without prejudice.
by next week, Lordship, I will find out whether it passed an order also. That I will say.
Deal is the matter. Next week, AG accepts notice for the response.
Right.
You find out. Yes.
Serial number 2. Ravi Shankar.
Yes, Anmati. Unsigned notice.
Yes, Your Honor.
Lordship, the assessment order Miladi is of 2022.
That may be so. If on the face of it, unsigned notice, it's without jurisdiction, there ends the matter.
If I am relying upon section 282A, my lord, subsection 2. Page number 1.1418. Two 82A, my lord.
authentication of notices and
Time
other documents.
ರೂಲ್ಸ್ ಎಲ್ಲರಿಗೂ ಒಂದೇ ಅಲ್ವಾ?
Yes.
Authentication of notices and other documents, where this act requires a notice or other document is to be issued by any income tax authority. Such notice or document shall be signed and issued in a paper the forum or communicated in electronic forum by that authority in accordance with such procedure as may be prescribed. Every notice or other document to be issued, served or given for the purpose of this act by any income taxer shall be deemed to be authenticated if the name and office of a designated income tax authority is printed, stamped or otherwise written thereon. Subsection 2 clearly says that name and designation is, if it is clear, not that is sufficient.
Yes, what do you say?
Your Honors, we'll pass this statement. I relied on a judgment which is at Annexure G of the Bombay High Court. And my learned friend last week was mentioning that they have preferred a writ appeal in a different matter. This judgment, which is at Annexure G, has distinguished those two judgments which he was gracious enough to give the petition. I'll take it on us to page 120. There is a case review middle of the page.
Page?
120. The petition. There's a case review.
Yes.
The second paragraph, CIT versus Anand and Company and Skylight Hospitality, if your honors will see, is shown as distinguished. Immediately above that, BK GUI, which I have just given across to your honors, is followed. Now I will just read, take your honors through BK GUI.
But whether this 282A2 is been considered?
It has been considered. It is considered at length. I will just point out. And they have followed the decision. I have just passed over this decision of BK GUI. This is one of the first decisions on the point. This is on the same issue of signature, whether there was waiver. And take your honors to the finding. My learned friend read out section 282, which finds a mention in the order passed. I just this pertains to the old act, nevertheless. May I take your honors to page 5, your honors, 5 of 11? 4 of 11, I'll start from 4 of 11, your honors. Last paragraph. The word notice.
Yes.
The word notice carries, according to Oxford Concise Dictionary, meaning intimation, intelligence, warning. The words give notice, have notice mean formal intimation of something or instruction to do something. Hence, according to its ordinary English meaning, a notice need not be in writing. In case of Maharaja Mills so-and-so, Supreme Court held so-and-so, they have relied on case laws. Difference in the provision in the two subsections with respect to giving notice is significant, indicates clearly the notice which the court is to give to the parties, the filing of award need not be notice in writing. Notice can be given orally. This is in respect of what can be a notice by the court. It follows from these consideration decisions that there is no express provision or provision by necessary implication that the notice must be in writing and writing only. It is sufficient if verbal notice is given. It is for this reason that the legislature, when it thinks in its wisdom that a written notice should be given, makes provision in one or more of the sections of the Act itself. Section 7 of the Public Demands Recovery Act, 14(1) of the Arbitration Act, Section 6 of the Parsi, so-and-so. The legislature may again provide for written notice in the Rule 20 of the Public Demands Recovery. It is an illustration in the class. The legislature may again leave the matter at discretion of executive authorities who may, by framing rules, require a written notice. Rule 18 of the Income Tax is an illustration of this class.
legislature may again do it by prescribing a form. Hence, it is necessary to consider firstly whether section 34 required a notice in writing. It was at one stage considered and we have the revenue that notice under 34 must be in writing. It is however difficult to say in view of the subsequent arguments whether revenue had stuck to the same concession. Be that as it may, it is clear that the words has reason to believe. This is on 34, there is 148, Your Honors. I will go to the next paragraph. The legislature may again not require that notices
To the
be in
last one. A notice under section
34 cannot be issued mechanically or as a matter of routine, for it seeks inter alia to disturb the assessment already made and finalized. Hence, it imposes upon the assessing officer to apply his mind to the matter before seeking to unsettle the matter to the detriment of the assessee. The income tax officer must satisfy that he has reason to believe that by reason of the omission or failure of the part of the assessee to make a return of his income under section 22 for any year or to fully disclose truly and fully all material facts necessary for the assessment for that year, that income, profits or gains or chargeable to income tax have escaped assessment for that year or have been under assessed or assessed at too low a rate or has been made the subject of excessive relief under the act or excessive loss or depreciation allowance has been computed. The foundation of the jurisdiction of the assessing officer to disturb the early assessment is not circumscribed only to the grounds related above. Income tax officer in the alternative must satisfy that in consequence of information in his possession, he has reason to believe that income and profits of gains chargeable to income tax have escaped assessment for any year or have been under assess, so and so, so and so. These again do not give him jurisdiction to issue a notice. He must satisfy himself that is within a period of 8 years in the first class of case and within a period of 4 years in the second class. It is only then these two conditions satisfied and the assessing officer is competent to issue a notice under 34. The signature along with the seal below the notice or maybe without it would be a guarantee beyond doubt that the income tax officer has exercised his mind over the points mentioned in 34.1. If the notice does not bear a signature, it may be that is issued from his office by mistake, or it may be that he has not applied his mind to the points involved in section 34. Therefore, in my opinion, on a consideration of the second part of 63.1, read with order 5, rule 1 and 10, signature on notice is not only necessary, but an integral part of the notice. They have gone into civil law to say that if the notice is not there, you cannot treat it as valid. This is one of the first decisions on the point. I just
And section 282A was not there.
they have gone on.
282A has been inserted with effect from 2008.
Here there's interpretation of civil law, what a notice requires.
2008. The object will be defeated, Lord. The purpose of insertion is that the mistakes in the procedural mistakes has to be diluted. If it is name and designation is shown in the notice, that is sufficient as per section 2. This provision was not there in the old act. This decision is not applicable.
No, I will rely on the Bombay decision which is there in the petition. I will just take your honors through that.
But 282A, there's a point in which the department is raising.
I'll just point out. 1 second.
But one more point is that a writ lies to the High Court when there is a breach of fundamental right law, violations of principles of natural justice, excess of jurisdiction, challenge to the rights of the statute. So all these 4 contents are not
So
present
that,
in this case, Lord. The honorable justice the High Court, Lord, has said that if these conditions are not satisfied, it is not pensionable. In this case called Southern Expatriate and Energy, the court has said that the procedural lapses cannot be a ground for filing this petition. I pass on the judgment.
no, we'll see, but if it's without jurisdiction, it will lie. But whether it's a matter without jurisdiction, he has to show.
You know, they have not rebutted the point that the officer has made. He's admitting there is a mistake.
I'm not admitting. Lord.
No, but
Even
282, capital A is by way of an amendment.
Please, your honors.
And now they say that the signature, it
In
appears
the
to be-
judgment which I have given, they have relied on, they have answered 292B.
No, but this amendment was in 2008.
Please, your honors.
And in Southern Chhattisgarh High Court, 282A is considered, where I am relying upon.
But
This is squarely on the point of 148 and This is a decision rendered in 22.
In southern.
This is a subsequent decision of January 2023.
So Lordship, in this case, the assessee had taken the contingent.
Which paragraph, which para?
So Lordship, the paragraph number 6, my lord. Considering in this situation is primarily with respect to the initiation of proceeding under section 148 is raised only on the ground that of non-issuance of sanction order under section 151 of the act by competent authority. Perusal of the sanction granted by the competent authority at page number 35 would reflect that it bears in document number. These documents specifically bears name and designation of authority according to a sanction or approval under section 151 of the IT Act. Hence, without the submission of the learned counsel for the respective parties and considering the documents based on record wherein is specifically mentioned, I do not find any merit in submission of learned counsel for the petitioner. Pleading in reply, particularly in next paragraph, my lord, I will just skip to last paragraph number 8, my lord. Honorable Supreme Court in case of Assistant Commissioner has considered the maintenance of petition when alternative statutory remedies available and held as under. The respondent had a statutory remedy under section 107. Instead of availing the remedy, the respondent.
No, anyhow, you just have a look at it and come back on 282A. We'll see.
May I,
But there's a point in what he's saying.
may I just,
Yes.
if I may, if you honors were to, there is serial number 12, same issues there. It can be taken along with serial 12. There's a decision of the Allahabad High Court which they have considered 282A on the same issue,
Pass
on the 151. It can be taken along with 12,
along with 12.
please. Sir, serial number 3 is.
Three,
Millards, I am here on
Number 3. This petition is where we have challenged 148AB being less than 7 days.
2 with 12.
Page 42.
Millards, I am appearing here.
Number 3 and 3 and 3.
Serial number 3?
I'm here in the online.
Serial number
I'm-
3.
Yes, Your
Am
Honor.
I audible?
Yes. Yes.
Yes.
The 148AB is in challenge, Your Honor, for
Ah.
being less than 7 days. I have relied on 2 judgments, which is at annexure B and C. B is of the Bombay High Court and C is of the Jurisdictional High Court.
148AB itself says.
Yes, Your Honor.
Isn't it?
Not less than 7 days.
Ah.
So there is a contravention. So
Ah.
on that short point,
Yes.
notice has to be quashed.
Yes. One 148A B, isn't it? B.
Notice 148AB.
Yes.
You'll find it under 148. May I read yours,
No, I've got it.
please?
Now we'll allow this only on that point.
Yes, Millards.
Yes. The petitioner has called in question sought to challenge the notice under 148 capital A small b of the act
Hello? Idea madam ida.
at annexure A and consequent
ಹೌದಾ?
order under 148 capital A
ಆ number
within bracket D as well as notice under 148 at annexure A2, order under 147 read with 144 at A3, order of penalty at A4 and A5, and order under 147 read with 144 at A6. But there's only one point. You should come at the earliest point of time. You wait till the order is passed.
You know,
Then you raise.
the SSE was not registered in the portal itself. When they made recovery, we have realized that all the orders have been passed.
So it's ex parte proceeding.
Ex parte, yes.
Full stop. It is noticed that the notice under 148 capital A within bracket small b of the Act issued on 21/3/22 directs for submission of reply by 25/3/2022. Full stop. Now, before I dictate, just point out it was ex parte. Any reference?
Please, Your Honors. If Your Honors were to take to annexure A3,
Annexure,
A3, page 48.
page
8. Middle of the page, it says 147 read with 144. And page 50, they have made a tabulated chart to say that not complied. The SSE had not even logged into the portal. We did not have access.
Yes. It is the. What is this annexure D you are relying on?
You know, annexure D is the guidelines. Now, what happens is the guidelines stipulate that the department must share the 151 sanction, which is not shared for that short point. D and D1 are guidelines to the department, internal communication, that when they are issuing a 148 AD, it must be accompanied by a 151 order. It is not done mostly.
The admitted facts being that the petitioner has not participated in the proceedings, which the petitioner asserts is due to bona fide reasons, as he was not intimated, nor was there any notice.
Yes.
Full stop. Next, it is to be noticed that section 148A(B) provides for notice not less than 7 days. Full stop. 148 capital A subclause B reads as follows. The mandate for giving notice of not less than 7 days for reply is a statutory mandate, and the Central Board of Direct Taxes, by its direction, by the guidelines issued for issuance of notice under 148 of the Income Tax Act 1961, reiterates at Roman 7 that 7 days notice is required to be given as regards the show cause notice under 148 capital A within bracket B of the Act. Roman 7 reads as hereunder. Clearly, in the present case, the time limit prescribed has not been adhered to. Clearly, there is a violation of the legal mandate insofar as the period of notice prescribed, and the contention that it has caused prejudice requires to be accepted. It is further noticed that the petitioner not having participated in the proceedings, it would meet ends of justice by affording another opportunity to the petitioner to take part in the proceedings. Once the notice itself is one without jurisdiction and cannot be condoned, the consequential proceedings, including the 148A(D) order and subsequent proceedings, are liable to be set aside on the only ground that the notice suffers from violation of a statutory mandate and vitiates the subsequent proceedings. Accordingly, the notice at
A to A6.
notices at annexure A to A6, the notice at annexure A and the subsequent proceedings at A1 to A6
Please.
are set aside, while liberty is reserved to the revenue to take appropriate action as regards to the subject matter of the notice under 148 capital A within bracket B of the Act, and the petitioner would not take up any contention regarding limitation in light of exercise of discretion of setting aside the notice, those subsequent orders are passed. Accordingly, petition is disposed of.
Obliged.
Achha.
Serial number 4, Harish.
Yes,
My lords, this is a case where I had furnished
yes, Jeevan. Yes,
I had furnished the bank statement and also the challans filed by the vendor, my lords.
I'll just verify, my lord, I'll ask you have it next Wednesday.
My lords.
It matter has to go back if that is the. Now they say that, my lord, the vendor
Interim-
has discharged the, my lord, the tax.
Let us, interim order earlier granted is extended till the next date. Delist the matter on 19th.
Please.
19th. You must chase him. You must chase them.
Not to chase, sir.
Yes, yes.
5,
Appear for petitioner.
two ಬಂದು pass ಅವರು.
Yes.
Three ಬಂದು pass ಅವರು.
This case, the subsequent order has been made. Notice has been issued, madam. I have furnished certain documents, madam. Thereafter, one more notice has been issued to furnish the submission supporting documents, madam. I sought for one adjournment, madam. That has been refused, medical ground. Ink page number 36, my lord, you will also kindly see. Page number 36. When say show cause notice. 48 2002.
Yes.
48 was issued to the RTP requiring him to show cause as to why he should not pay the amount specified in the show cause notice dated so and so, and cited above under reference number 3.6 is issued by this office through registered per email on 14/8/2023 as per 169(1)(c) of the KGST Act 1970. The taxpayer has replied to the same and has produced documents. However, in this reply, there is no submission of supporting documents for the payment done. Hence, the produced reply is not found acceptable. Further, the taxable person was provided an opportunity for personal hearing through notice dated 18/3/2022 issued through mail, and the taxpayer has not appeared for the same, but has requested time through mail reply, which cannot be considered as the opportunity has been provided in this adjudication procedure. Your Lordship, 75/4, my lord. One adjournment I have sought for. 3 adjournment is required to be issued. 75/4, my lord, your Lordship kindly recommend. I have extracted also. And ink page number 7, my lord. I have extracted paragraph 8. In 75, which is subclass 4 below, an opportunity of hearing shall be granted where a request is received in writing from person chargeable with tax or penalty, or where any adverse decision is contemplated against such.
What is the reason assigned for adjournment?
Pardon?
What was the reason for adjournment?
His daughter is unwell.
Daughter is unwell.
But daughter is hospitalized, my lord. Therefore, I requested one time. Anyway, my lord, 3 opportunities should be given under section 75/5, my lord.
Where is the adjournment request?
Yes, ma'am.
Sir, F, page 32.
Page?
32.
32, my lord. Ink page number, annexure F, my lord. Ravindranath Tagore. part
Then
of
you
so and so.
redo it.
He is suffering from
But
ill.
we initiated the proceedings, my lord, on 28/12/2023. Could have sought for a personal hearing anytime between those dates. Almost 3 months' time was there for him to ask. At the nth moment, my lord, he comes and asks for a personal hearing.
It is,
Yes.
the petitioner has sought for issuance of writ of certiorari to set aside the impugned order at annexure G and consequential demand notice at annexure H. Full stop. He submitted that during the course of the proceedings, petitioner had requested for time in terms of the request at annexure F on the ground that his daughter is suffering from fever and other medical ailments, and hence was not able to attend, would not be able to attend the personal hearing dated 22/3/2024. This request as regards to the stage of personal hearing has been declined as is noticed in the order under section 73 of the Act at Annexure G.
G and H.
Full stop. The assessing officer, isn't it?
Yes,
Has
adjudicating officer.
the adjudicating officer has declined request for adjournment, stating that opportunity has already been provided in the adjudication process. Full stop. Learned counsel for the petitioner submits that section 73(5) ought to be kept in mind, which provides for restriction regarding grant of adjournment after 3 occasions. Full stop. Learned counsel for the revenue submits that request ought to have been made much at an earlier point of time. Full stop. Heard both sides. It is not in dispute that a request for adjournment has been made. The assertion that this was the first request for adjournment at the stage of opportunity of personal hearing is not controverted. Full stop. Section 75(5). 75(5) is it?
75(5) money.
Reads
Plus
as
5 of 75.
reads as follows. Full stop. Section 75(4) reads as follows. Next, it is clear that an opportunity of hearing shall be granted where request is received from the person chargeable with tax or penalty, where any adverse decision is contemplated against such person. Where the request for adjournment is made and illness of the daughter of the SSE is made out as a ground, the adjudication officer has in a very hyper-technical manner rejected such request while not noticing that this was the first adjournment at the stage of opportunity of personal hearing. Taking note also, full stop. Accordingly, it would meet ends of justice in setting aside the order and remanding the matter at the stage of opportunity of personal hearing as contemplated under 74(5). All contentions are kept open. Order at Annexure G and the consequential order at Annexure H and the consequential demand notice at Annexure H are set aside. Shall we fix a date or not required?
Fixed date.
Petitioner to present himself to avail of the opportunity of personal hearing on
2 weeks, my lord.
2 weeks.
Here, Vara.
28th.
28.
Yes. Now 74(5) and 75(5) are linked, you can see. So we could read the proviso of 75(5) even. Yes.
6, Suresh Babu BN.
Ex parte assessment order, my lord.
Lordship, ex parte assessment order, they have not filed any reply to the notice on the section 148A. If they are able to produce any documents, may not let it go back and let them contest the matter.
Yeah.
Paragraph number 5, my lord, page number 14 of the assessment order.
Page?
Page 14, my lord, para 5. They have not appeared and they have not filed any response. So order has been passed.
Now what the Council for Revenue is saying, no doubt we will consider.
Please.
But prima facie, you make out you just show that there were grounds for you to make out a reply.
Lord, what has happened is, my lord, it is in pursuance to a sale deed, my lords, may kindly take page 50, page 47, my lord. It is a small bit of house, my lord, what it was been possessed by the petitioner before your lordships, my lord. An entire extent of land was sold. Lords, may kindly turn to page
page 62, my lord, 63, my lord, sorry, 63. The sale consideration, what it has been received by the petitioner is only 6 lakhs rupees, my lord. Whereas the assessment, they have taken the average value of the property and they have divided that into the number of vendors and fixed 59 lakhs, my lord. What it has been received, my lords may kindly turn to page 63.
No, this is a joint,
Yes, my lord, joint sale deed. She was possessing a small bit of land which was in the hind side. They fixed only 6 lakhs, my lord. And she is,
where do you get that?
my lord, page 63, my lord. Page 63. The petitioner before the lordship is vendor number 5 in that sale deed, Manjula. Page 63, my lord.
Item,
G, my lord, phase 63, G, 6 lakh rupees through check bearing number so and so, drawn on City Union Bank, Sultanpet, Bangalore, issued in favor of fifth vendor.
fifth vendor is,
Manjula, my lord. Milas may kindly come to page 51. Fifth vendor is Manjula.
they have taken the entirety of amount.
Yes, my lord. And they have assessed, they have taken average, divided into the number of vendors who have sold, and they have assessed it at 59 lakh 60,000, my lord.
Your Lordship, entire TDS has been made in the name of petitioner, my lord, page number 14.
No, correct, that,
Let them explain that it is only, they belong, only 6 lakhs has been received, my lord. Let them demonstrate before the.
Please, please, my lord. Because it is received by way of a check.
yes. And also, we have said that it was income that has escaped.
Chargeable income.
The petitioner has challenged the assessment order under one past under 147 read with 144 of the Income Tax Act on the ground that you were served with notice or no, you were not served.
My instructions are she was not served, my lord. She never filed income tax returns in her lifetime. Only she's got done PAN number in her name. And she's a relation lady.
No, she was not served with notice. Full stop. It is further submitted that the petitioner is not an SSC and the sale consideration on sale of immovable property has been taken note of and an amount of rupees 59,90,248 is brought to tax under the head short-term capital gains. Full stop. However, it is submitted that in terms of the sale deed dated 28/3/2018.
Please, my lord.
The petitioner herein is the fifth vendor and her share is only 6 lakhs as per the check dated 16/3/2018. And if that were to be so, the order passed taking entirety of consideration and taking an average as regards each of the vendors, contrary to the actual sale consideration received, makes out a strong ground on merits as well, and accordingly seeks for affording an opportunity before the authority. Now, at which stage it will have to go back?
Your Lordship, they have to file reply to 148A(B), my lord.
Taking note of the fact that
Your Lordship,
petitioner,
the reply to 148 notice, my lord, 33/2022.
in light of such facts as made out, the matter is relegated to the stage of reply to the
148 notice. This is old, my lord, before amendment.
to the 148 notice. Full stop. The order at annexure A is set aside on the ground that petitioner has not participated in the proceedings. All contentions are kept open. Petitioner to make out reply to the 148 notice within a period of
2 weeks, my lord.
3
Sure,
weeks from date of receipt of certified copy of this order. Accordingly, petition is disposed of. All contentions are kept open.
Yes.
I have a
Seven.
dispensation order. I have a dispensation. Petition is dispensed with production of certified copy of the orders. Yes,
This is a case where I could not file my objections to the 148A.B. I am a trust school where my receipts are less than 1 crore. I am entitled to the benefit of section 10.23C. It says that when the receipts are less, my income is not taxable. But the assessing officer says, since you did not file the return initially, he taxed the entire gross receipts. So all I'm praying is that if I'm permitted to go back to stage 148A.B, I will file my return because Murnad is a small place near Madikere.
income tax.
Income tax. I think Tirumalesh.
Tirumalesh will take. Exemption, he will take.
You serve copy, we'll have it next week.
Please, Yamas. 18th or 19th, date.
Sri Tirumalesh is directed to accept notice for the respondent. This is the matter in a preliminary hearing list on 19th.
Obliged.
8, Ravi Raghavan.
This, your lordship, is rejecting my export transactions and holding me to be an intermediary at
Central tax.
central tax. And similar matters, your lordship, for me, my lords have passed stay orders. And there's a periodical notice, your lordship. My lord, the serial number 8, your lordship, is for the period March 21 to September 21. And serial number 55 also is, your lordship, on the same issue, same assessing. That, your lordship, is for the period October 19 to March 20. Serial number 8 and serial number 55 here.
Serial number 8 is for which period?
October 2020, your lordship, to September 21. Serial number 55, your lordship, is for the period October 19 to March 20.
Yes.
For the earlier periods, your lordship, matters are before my lords. My lords have granted us relief in terms of interim protection, your lordship. So the same protection can be given, your lordship. Our only one request is the stay orders, your lordship, is at page 130. 131, 132, your lordship.
Annexure?
Page annexure F, your lordship, page 131, 132. 32 on the top, your lordship. And all these, your lordship, are refund matters.
Page 127. 128.
No, your lordship, 128 is an invoice. Page 131.
No, 128 is the order. In writ petition 13007.
I was
It
referring
starts
to your
from
lordship-
121, my lords. Annexure F.
I was referring, your lordship, to 14011, which is serial number 8.
140.
Correct, huh? Okay. Same, your lordship. The order, your lordship, is dated 31/3/2023, your lordship.
Yes, annexure F.
Annexion.
F.
Yes.
Yes.
Only one request, your lordship,
Yes, Jeevan, please.
only one request, your lordship, all these refunds as of now, your lordship, is about 55 crores, your lordship, on the same issue of intermediary. And we are, your lordship, according to us, we are covered by a circular that has been issued by them explaining what is intermediary. And we are fully covered by that circular. There are about 3-4 decisions, your lordship, the Delhi High Court as well as the Punjab Haryana High Court explaining what is intermediary. So according to us, your lordship, these would be covered. My lords could have all these matters together on any day, your lordship. Maybe at 2:30, they can also file their counter if required. Because these are all orders, your lordship. We are not challenging in the constitutional provisions. Orders speak for themselves. So whether even if without a counter, your lordship's matter could be.
Just along with WP 10315 of 23,
2023.
4580 of 23, 6151 of 23, 24368 of 23, 13007 of 24, 14011 of 24, and 23458 of 2023. Full stop. It is submitted that in all these matters, the legal question and the factual matrix are almost identical, and that this court in WP
6151 now.
6380 of 2023 and 31/3/2023 has passed an interim order. And on the ground of parity, in the present matter also, there may be an interim order on same lines. Order of 31/3/2023, page 122, reads as follows. Next, in light of the same, there would be an interim order directing the respondent not to take any coercive measures consequent to the rejection of refund.
Fix it, your lordship, then my lords can, any day at 2:30, your lordship, about an hour it will take, so that all these matters can be taken up for consideration.
Pleadings are completed in any one matter, they are filed.
No, your lordship,
I'll
because the
complete it.
first matter, your lordship, the first order, your lordship, is of 31/3/2023, more than a year before. And on one side, your lordship, counter is not being filed. The other side, your lordship, consistently orders are getting passed again.
List the matter at 2:30 on 26th. Pleadings to be completed by the revenue by then.
Or both the matters, serial number 8 and 55.
55. All the matters, your lordship. 8 and 55. your lordship.
55 is there in the list which you have given.
Yes, sir.
Hmm.
13007, correct? 14011, last but one.
55 to be called along. Idrili they listed. Yes,
Great.
petition number idrili. Yes.
You appear for the petitioner, my lord, in this case.
Just 1 minute. Adali, Jeevan accepts a notice for the respondents.
Lord, annexure A, my lord, is the impugned adjudication order, my lord. The two grounds, my lord, the demand is raised. The first ground, my lord, is the difference in GSTR 2A and 3B. That is the first ground, my lord. The second ground is the refund of it is regarding refund, my lord, which I have claimed belatedly. So on these two grounds, my lord, a demand of 7 lakhs is raised, my lord. In so far as GSTR 2A and 3B is concerned, my lord, the total amount of tax is, my lord, about 3 lakhs 95,000. My lord, I have all the invoices, the bank statements, my lord, to show that I have in fact purchased these goods and I have discharged the liability, my lord, of tax. Now the difference, because the supplier hasn't, in fact, the supplier also has given me a certificate, my lord, that he has uploaded the invoices and paid the taxes. I have the certificate also, my lord, with me, my lord. But they say because there is a difference and it is not reflecting in their portal, they have raised this demand, my lord. That is the first ground, my lord. The second ground is, my lord, I belatedly, 2 years is the time period, my lord, to claim refund. I have claimed the refund after the 2 years.
16/4. Huh?
After 2 years, my lord, I've claimed refund. No, I'm not raising any objection to return of refund, my lord. I'm willing to return that money. But my lord, they've charged me interest on that refund. My lord, interest under section 50, my lord, of the GST is leviable only in two cases, my lord. One is if I don't pay taxes, if there is any non-payment of tax or short payment of tax. The second ground is, my lord, if I have availed excess ITC. In the present case, my lord, is not a case of non-payment of tax, nor a case of levying excess, availing excess ITC, my lord. It is a case where I have wrongly availed a refund, erroneous refund, my lord. So for erroneous refund, my lord, there is no interest under section 15.
The same. No, correct. Now, insofar as this reconciliation of 2B and those returns, that some circular that day we referred, isn't it? Circular not required.
Just verify with regard to.
Just check if that is so, wherever there is a difference between those two returns, it could be disposed of saying you follow the. We'll have it next week. 25th. Till then,
Lord,
what is the interim prayer?
Lord, interim prayer, we have sought for stay of the impugned order, my lord. But they have already, my lord, they've attached my bank accounts in excess to this money, my lord. Whatever demand is raised, my bank accounts have been attached for that sum of rupees 7 lakhs. So there may be no conditional order, my lord. It may be stayed. They've already attached my bank accounts, my lord, for the extent of this sum.
The respondents are restrained from initiating proceedings further to the order in original at annexure A and summary order at annexure A1 till the next date. Relist the matter in the same stage on 25th. You have a look at that circular.
Yes, my lord.
Which one?
That circular, my lord, which says less than 5 lakhs. The amount is less than 5 lakhs, they have to inform the taxpayer that a certificate from the supplier would be sufficient, a declaration from the supplier that he has paid the taxes, my lord, would be sufficient.
So you take your thing. So all matters, if this applies, we can follow the procedure. Yes. Yes. Don't take it. The circular very matters take out.
Lordship, 10, Lordship, I could not get instruction. Can you have it on Tuesday, my lord?
On Tuesday. Relist the matter on 18th.
Very good. Well, let's go, the interim order be extended.
Interim order earlier granted is extended till the next date. It can be disposed of, is
It
it?
can be
Yes, my
discussed.
lords. My lords, on the last occasion, my lords had asked me to prepare a short tabulation of the notices and my responses. I have done that. Do I hand it over today, my lords?
Yes, let it be in the file.
My lords, could it be listed in the orders list on the next date?
Same statement.
Same state. Relist the matter. Brief note file on behalf of the petitioners taken on record. Relist the matter in the same stage on 18th.
Great.
Let's in this matter, we are challenging the audit rules, which is 101. They are ultra wise to section 65. It's because they confer power on the proper officer to conduct the audit, whereas the section confers the power on the commissioner to conduct the audit. We kindly have section 65.
Yes, who appears? Central tax?
Hello?
Central tax.
Which one? You have served the court.
Copy.
MS service station. You must have got the copy. Minutes. Section 65 minutes.
60.
of the CGST Act? Subsection 1, my lords.
Yes.
Minutes. Subsection 1, the commissioner or any other officer authorized.
Subsection, section
Subsection
65.
5. Subsection 1, my lords, of the CGST Act.
Yes.
My lords, the commissioner or any other officer authorized by him by way of a general or a specific order may undertake audit of any registered person for such period at such frequency and in such manner as may be prescribed. So let subsection 1 confers specific power on the commissioner, or he may delegate that power to any other officer to which he deems fit, and the manner and the frequency will have to be prescribed. So now let's kindly have the definition of prescribed. It is section 2, clause 87.
Just read once more.
Minutes. The commissioner or any other officer authorized by him by way of a general or a specific order may undertake audit of any registered person for such period at such frequency and in such manner as may be prescribed.
So it's the commissioner or any officer authorized by him.
The commissioner is the authority to which the power has been conferred upon, and he may delegate his power to any other officer to which he deems fit. Now, the audit, as per subsection 1, the period, frequency, and manner will have to be prescribed. The word prescribed has been defined under section 2, clause 87.
The prescription as regards period and frequency.
Period, frequency, and manner.
Yes.
Let's the word prescribed has been defined under section 2, clause 87.
Yes.
It means prescribed by rules made under this act on the recommendations of the council.
Yes.
So the ambit of the rules would pertain to frequency, period, and the manner, but the power of audit can only be exercised by the commissioner or the officer authorized by him. Now let me kindly have subsection 2 of section 65.
Yes.
The officers referred to in subsection 1 may conduct audit at the place of the business of registered person or in their business or in their office. The registered person shall be informed by way of a notice not less than 15 working days prior to conduct of audit in such manner as may be prescribed. So as per subsection 3, a notice will have to be issued necessarily by the commissioner or the author or the officer authorized by him, but the manner of issuance of notice will have to be prescribed by the rules matters. Now let me kindly have subsection 4. The audit under subsection 1 shall be completed within a period of 3 months from the date of commencement of the audit, provided that where the commissioner is satisfied that audit in respect of such registered person cannot be completed within 3 months, he may, for the reasons to be recorded in writing, extend the period for a further period not exceeding 6 months. Let's subsection 5 now. During the course of audit, the authorized officer may require the registered person to afford him the necessary facility to verify the books of accounts or other books as he may require, to furnish such information as he may require and render assistance for timely completion of the audit. Now let's subsection 6. On conclusion of the audit, the proper officer shall within 30 days inform the registered person whose records are audited about the findings, his rights and obligations, and the reasons for such findings. So the audit will have to be conducted by the commissioner or the officer authorized by him. He will issue the notice for audit also. After completion of the audit, which is undertaken by the commissioner or the officer authorized by him, the proper officer can only apprise the concerned person regarding the rights, obligations, and the findings. Now, let's kindly have rule 101, which is the concerned rule for audit.
Yes.
sub-rule 1, the period of audit to be conducted under subsection 1 of section 65 shall be a financial year or multiples thereof, where it is decided to undertake the audit of a registered person in accordance with the provisions of section 65, the proper officer shall issue a notice in form GST ADT 01 in accordance with the provisions of subsection 3 of the said section. So there the power is conferred upon the commissioner. Now here the power is conferred upon the proper officer. Sub-rule 3, my lords, the proper officer authorized to conduct audit of the records and the books of account of the registered person shall, with the assistance of the teams of the officers and officials accompanying him, verify the documents on the basis of which the books of account are maintained.
Let us see.
Now let's may kindly have the definition of proper officer as well as the definition of commissioner.
We'll see, we'll consider it. Let us.
My lords.
What have you challenged here?
We have challenged the rules as well as the impugned order. Rule 101, sub-rule 2, 3, and 4, my lords.
Will not comment on the rule as of now.
My lords.
What is the interim order you are seeking?
We are seeking the stay of the impugned order, my lords. And no further proceeding may take place.
On merits, what is the case?
Let's apart from this, let's kindly have section 65, subsection 7 again. Let's
65.
subsection 7.
Yes.
It says that where the audit conducted under subsection 1 results in detection of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized, the proper officer may initiate action under section 73 or 74. So the initiation of 74 proceeding will be contingent upon the finalization of the audit. If such audit has resulted into evasion of tax or tax not paid or ITC wrongly utilized, then he may issue the notice. In this case, what has happened is, audit notice was issued. He issued an inquiry. We filed a reply without passing the final audit report. The show cause was issued. So unless and until the findings are confirmed under the audit report, the show cause under section 74 cannot be issued. This is what section 65 subsection 7 clearly says, my lords. The audit should result into non-payment of tax or wrongful availment of ITC. If the audit itself is not, it is sub judice, it is not completed, how could they have issued the show cause notice, my lords?
Let us see.
My lord, one submission in this regard. The proceedings under section 65 and proceedings under section 73 or 74 are very distinct and, my lord, different. They are on, my lord, on their own. Now if the section 65 cannot be, my lord, taken recourse to, that doesn't mean that, my lord, we cannot initiate action under section 73 or 74. They are not interdependent. Only on determination of, my lord, liability under section 65, I should issue a notice, my lord. That is not the mandate of law. Even if there is any other material is there, my lord, I can initiate, my lord, proceedings under section 73 or 74 as the case may be, independent of this.
Now under 74, they have issued a show cause notice.
In this case,
do they refer to any of the audit proceedings?
Let's see, they have referred. Kindly have page 93, my lords.
Page
93.
Have copies.
I'll just. Let's para 2.
Page
93. Annexure G, my lords. Show cause notice.
(65)(7) uses the word, my lord, may initiate action. My action may be based on this, but doesn't mean that, my lord, action under section 73, 74 should be preceded by an action under section 65.
May kindly have page 93.
But here under the 74 show cause,
they might have referred to it, my lord.
They
But
have.
that doesn't mean that, my lord, entire
What the
thing is-
word may he is referring to.
no, they refer to the observations made in the audit.
That might
My
be
lords.
that. But that doesn't mean that, my lord, without conducting section 65, you cannot proceed under section 73(4). That is not the mandate of law. 73(4) can, 73 and 74 can independently, my lord,
In light of the, any of, on the rules, there appears to be a point on the rules.
More recovery proceedings can be initiated based on the audit. Then after the audit report, it can be decided whether we have to initiate 73
Or 74.
or 74. In cases of not, 74 will be initiated. Then the
Otherwise,
procedure
it's
is again prescribed under 73 and 74. First, under 73 Mallards and 73(5), an intimation, TRC 1A is issued. They are giving them an invitation to pay the tax along with the interest and no penalty. If they fail to do that and if they file a reply to that notice Mallards, then proceedings are initiated under 73(1). Again, Mallards,
Same procedure.
May I just clarify one thing, my lords? The discretion which they are referring to, that discretion is only with respect to invocation of 73 or 74. In a case where audit has been conducted and that audit had been referred to show cause notice, my lords. If that audit results into evasion of tax, whether the evasion is willful or bona fide, that will lead to invocation of 73 or 74, because 73 refers to evasion of tax where there was no bona fide limits. There was no intent to evade. 74 refers to willful evasion of tax or willful availment of wrongful ITC mallards. So as per section 65 subsection 7, that may refers to invocation of proceedings under section 73 or 74, considering the facts of the case. If the facts are such of the audit report that there was no willful evasion of tax, then 73 will be invoked.
Here the audit proceedings have concluded.
What happened was they issued the audit notice, we filed reply. Without concluding, referring to the audit notice, they issued the show cause notice.
In light of the, let us see.
In
light of the contention that the show cause notice has been issued without awaiting finalization of the objections raised to the audit report, there would be stay of
Annexure A matters.
Annexure A. The revenue is at liberty to move for modification of the interim order upon filing statement of objections. Contentions are raised regarding the wires of Rule 101 subclass 2, 101 subclass 3 and 101 subclass 4 of the CGST rules 2017 as being ultra-vires section 65 of the GST Act, and accordingly statement of objections to advert to such legal ground specifically. It's made clear that the interim order is passed on the merits of the matter without reference to the challenge to the ultra-vires of the rules.
Let me record my.
G1 accepts notice for the respondents. List after 3 weeks.
Record my appearance.
Yes.
Samir Gupta.
Learned counsel so and so has appeared on behalf of the petitioner and made submissions. Yes.
Obliged.
Serial number 12 and 13 are from the same petitioner. There are legal grounds. There's an ex parte order. I am only praying for a remand back to stage of 148AB. I am a cooperative society. They have made additions of my entire cash. I think Mr. Tirumalesh would be this from Udupi.
I'm online.
12 and 13.
You find out. I'll have it next week. You get preliminary instructions. Let us see.
Yes, my lords. I'm coming to the court. I will just collect the copies.
Same date, 19th.
Learned counsel Tirumalesh is directed to accept notice for the respondents. Relist the matter in the preliminary hearing list on
19th. Serial number 2. You must have clubbed along. I'll just make a mention. I've given the case law.
Serial number 2 is passed over. He told that it is similar to this one.
No, the case law is in this particular petition. So I'm just seeking Your Honor's indulgence. On 282, my learned friend read out. I'll just point out. You must have annexure E. Decision in Vikas Gupta. I'm holding the petition at serial number 12, Your Honors. Is that serial number 12? Annexure E, Vikas Gupta versus Union of India.
Page?
Page 74, I believe it is. Page 76, it could be a mistake. High Court of Allahabad, Vikas Gupta versus, you honors have the page?
Yes, yes.
I'll take your honors over the page. The cases are listed. Your honors would take to page 83.
Paragraph 20. Paragraph?
Paragraph 17 is what the, 10 is what the respondents have submitted. The court has extracted rule 127. Then paragraph 15, Your Honors. There is italics. The object of 282A. Para 16, I will just read. What is required in 282A? Your Honors have para 16?
Para 16.
Please, Your Honors. Subsection 1 of 282A contains the following necessary conditions. Such notice or other document shall be signed by that authority and issued in paper form or communicated in electronic form by that authority in accordance with such procedure as may be prescribed. They have interpreted 282A. I'll come down to para 20, Your Honors. Signed meaning. The word signed has not been defined under the Act 1961, which is Central Act. However, it has been defined in section 356 of the General Clauses Act 1897 as under 356. Sign with its grammatical variations and cognate expressions shall, with references to a person who is unable to write his name, include mark with its grammatical variations and cognate expressions. Now, I'll take it on 23 and 24, saying when an order without a signature is not valid. I'll take your honors to page 20, para 25, page 88.
Just 1 minute.
Please, Your Honors.
Yes.
May I read para 25, Honors?
Yes.
Thus, the expression shall be signed used in 282A1 of the Act 1961 makes the signing of the notice or other document by that authority a mandatory requirement. It is not a ministerial act or an empty formality which can be dispensed with. Signed means to sign one's name, to signify assent or adhesion to by signing one's name, to attest by signing, or when a person is unable to write his name, then affixation of mark by such person. The document must be signed or mark must be affixed in such a way as to make it appear that the person signing it or affixing his mark is the author of it. Therefore, a notice or other document as referred in 282(1) of the Act 1961 will take legal effect only after it is signed by that income tax authority, whether physically or digitally. The usage of the word shall make it a mandatory requirement. Before I go further, question A and B, I just point out para 14 years, if I just apologize. What is the question for consideration? Previous page. Thus, the following questions arise for consideration. Whether an unsigned content in an electronic record said to be pushed through electronic media at a particular point of time can be said to be valid satisfaction of the PCIT under section 151 for the assumption of jurisdiction by the assessing officer to issue jurisdictional notice to an assessee under 148 of the Act. Whether impugned notice under 148 of the Act issued by the assessing officer without satisfaction or signed by the PCIT is a valid notice. Now I'll take your honors over the page, para 27. Question A and B is answered here, bottom of the page. First and foremost condition under subsection 1 of 282A is that the notice or other document to be issued by an income tax authority shall be signed by that authority. The word and has been used in subsection 1 in conjunctive sense, meaning thereby that such notice or other document has first to be signed by the authority and thereafter it may be issued either in paper or may be communicated in electronic form by that authority. Sorry. In the present set of facts, it is an admitted case of the respondents that the PCIT has not recorded satisfaction under his signature prior to issuance of notice by the assessing officer under 148 of that. 28 and 29 relevant, Your Honors. My only submission is judgment is my learned friend right and on, the department made a submission on 282. There is no finding on that. This is a clear finding on the interpretation of 282A1. That signature cannot be dispensed with. And a 151 is not a notice, it is an order essentially. And the assumption of jurisdiction cannot be an empty formality. So unless there is a signature, the notice is required to be quashed. And in my case, it is not a notice after due process. Mine is a case which is issued prior to 21.
Any of you verify? Verify, let us.
Because they have not dealt with subsection 2, my lord. They have dealt with only the subsection 1, my lord. Two
I object,
specifically
Your Honor.
states.
I
Two,
object.
well, as with subsection 2, nowhere it has been examined.
No, but as a matter of fact, verify from your records, what is the position?
May I just, for the satisfaction of the court, read subclause 2 here. 282A2. Every notice or other document to be issued, served or given for the purpose of the act by an income tax authority shall be deemed to be authenticated if the name and office of designated income tax authority is printed, stamped or otherwise written thereon. Authentication does not mean valid. It is not, if they had intended it to be there, they should have said signed.
Let us.
Earlier, the notices were physical. So authentication is, that means it's a original notice, but defective, which cannot be cured.
For just one clarification, 282A1, A1, my lord, states that if the notice requires, what are the content for requirement, my lord? Requirement has been stated in subsection 1, where this act requires a notice, requires a notice or other documents to be signed, to be issued by any income tax authority. Such notice or other document shall be signed. If these contents are not there in the notice or the order, then subsection 2 applies. What is the requirement for this issuing of notice or other document? If that requirements are missing in the notice or the order, then subsection 2, every notice or other document to be issued, served or given for the purposes of this act by any income tax authority shall be deemed to be authenticated.
Let us see. It requires some hearing, we'll see. Now, this is connected to these other matters, is it? Or
No, Your Honor. I'll provide a copy in this case, but we have taken this contention in the matter at serial number 12 and 13. I undertake to file a copy of that in serial number 2. Same case.
So this also adjourned on the same date.
Your Honor, this I have to.
We'll take it separately.
I leave it, Your Honor. It can be disposed of. I leave it. 19th, you can take it to 19th. I leave it to my friend.
Relist the matter on 19th.
Serial number 13.
No, but in this you may have to take some, you put it in writing.
Yes, ma'am. I will file statement of objection.
You may have to file a statement of objection.
It may be adjourned for 2 weeks.
No, so this we'll keep it separately.
Serial number 2.
2.
Please.
So serial number 2, what is the interim prayer seeking? We'll
prayer.
consider the interim prayer,
Please,
but
please,
you
Your
file your
Honor.
objection.
No, sir. Next, A to A4 maybe, A5 may be stayed, Your Honor. No, sorry, A4. A to A4.
Third counsel for the petitioner submits that the notice at annexure
A, my lord.
at annexure A is not signed. And accordingly, and places reliance on the order passed in
Vikas Gupta, this is Union of India. Your Honor, 448 ITR 1.
in Vikas Gupta versus Union of India reported in
448 ITR 1.
448 ITR 1.
Allahabad dated 8/9/22.
Allahabad. And submits that such notices without signature is an infirmity that cannot be got over. Full stop. Learned Counsel for the Revenue, however, relies on section 282,
A2, 282, A2.
282, capital A 2. Full stop. Matter requires consideration. In the interregnum, there would be an interim order of stay of
Annexure A to A4. Your Honor.
A to A4. Statement of objections to be filed. List after 2 weeks.
Yes.
Yes, obliged. Number 13, Ravi Shankar.
Same connected.
13, both are adjourned Friday. Mr. Tirumalish. Number 14.
Minutes, I'm just requesting to have it next week, minutes.
At request. Income tax,
Show me.
I'm for the respondent.
let somebody accept notice, I'll have
He
it
will
next
take
week.
notice.
Minutes.
I'm Tirumalesh.
Learned counsel Tirumalesh accepts notice. Relist the
But this,
matter.
this relates to Hubli, my lords.
No, we'll have it next week. He's seeking time. We'll see next week. Relist the matter in the same stage next week.
Number 15. Anshuman.
Yes.
May I please? Here, the matter where your lordship already for the financial year 18-19 directed the the AO to consider my submission that I am the scheme proponent. That I have taken the company, the petitioner company called Yashomati. The Kaveri Hospital has taken the company through resolution plan. I am the successful resolution applicant and I have paid 97 lakhs 57,000 and odd the full claim amount without any waiver, relief or concession. I have paid full dues, whatever they submitted the claim during the CARP. Without for none of the creators, all the creators I have paid full money. So therefore, now I am challenging the notice where the assessing officer, your lordship knows that they are not the legal equipment. They are the where they have wrongly relied upon the judgment passed by the Madras High Court in Dishnit. That also I have in my petition I have distinguished the Dishnit judgment where that judgment arising from the Section 10 order. Section 10 means the company itself applied for the voluntary CARP and then the promoter himself taken the company. So therefore the clean slate principle has led down by the Honorable Supreme Court in Ghanshyam Mishra, and also the recently the so many judgments followed by the various high courts. Recently in Vasan High Court, the Madras High Court has followed that even the criminal liability will not apply to the successful resolution applicant because there is a complete change of management. If the new management comes in, the old liabilities, penalties, offences, claims, waiver, whatever, it will not go to the new management. So therefore, the conveniently the AO relied upon the distant judgment and passed an wrong order incorrectly. Here, I am circulating the judgments. Please see.
It's coming for the first time.
No, coming to second time. It was already adjourned on 6th June.
I've taken notice on that day, my lord. After notice, this is first time.
It's on the interim prayer.
Yes, for a consideration of interim prayer.
As regards interim prayer, what are the submissions?
My submission is that here I have paid the money 97.57 lakhs.
That was
as per resolution plan.
That was the liability of the
income tax officer, income tax department. Sorry, income tax department. Please see the kindly take page number 120 for a moment.
120.
120. The Deputy Commissioner of Income Tax is seeking a clarification about their claim to the resolution professional, who is the administrator of the company during the corporate insolvency resolution process. Kindly refer to a letter on the above subject. Why refer? It has been requested to reconfirm the bank account details, mode of transfer for admitted a claim of rupees so and so. In the above case, it is confirmed that demand of this may be issued in favor of DCAT. Then in page 121, after I paid the money, the demand draft copy.
Just one clarification. Now the demand is raised for which year now?
For the assessment year 2021.
2021.
Please see, the CARP was initiated on 16/3/2021.
So as on that date, insofar as the liability of 2021 was already crystallized.
Yes, crystallized, and they have filed as a claim with the resolution professional. That is the administrator of the company.
that has been paid by me in full.
Now what is the demand now?
They are asking me, madam, they are, please see, madam, they are, madam, from the TDS 26 AS, they are saying that they have paid so and so DDS, they have deducted so and so DDS. You did not, you failed to file the TDS return. You failed to file the financial return. Madam, my contention is that.
No, are they seeking to reopen under 148?
Yes, yes. For that, madam, kindly take your lordship order last time not passed. I only appealed your lordship, madam. Your lordship please to direct them, madam, to consider my submission under clean slate theory, madam, relying upon the section 32A and 238 of the IBC on judgments, madam, circulated by me, madam, and Ganesha Mishra. Page 123, madam. 145, madam, the order starts from. My name only mentioned in the order also. Please see, madam. Para 148, madam. Para 2. It is the contention of the petitioner that Yashovamati Hospital Private Limited was subject to insolvency proceedings under the INB code, and the resolution plan has been accepted by the order of the NCLT Bangalore bench dated 30/5/2022. As a result of which, the revised resolution plan as approved by the COC as submitted by Kaveri Hospital Medical Care India Limited has been approved. It is submitted that by virtue of the Kaveri Medical Care is in charge of Yashovamati Hospital India Private Limited, it is submitted that a notice under section 148 of the Act was issued to the S12 entity Yashovamati Private Limited, which now has been taken over by Kaveri Medical Care India Private Limited. And an order.
Just no, it requires some consideration. Let us.
Well, Ashok McKinley, the annexure L is the impugned order, my lord.
No, now,
Yes, ma'am.
annexure E
Yes, ma'am.
is a confirmation. You pay so much,
Yes, ma'am.
isn't it? That is for the year 2021. Now, whether once the resolution plan, your liability is crystallized at this amount, whether you can reopen under 148 is doubtful.
Yes, your lordship, McKinley, this is for the financial year 1920, my lord, the assessment year 2021, my lord. Your lordship,
Whatever it may be, my lord, I am the new management here. They have crystallized the dues and paid.
will just complete my
Sorry.
submissions, my lord. The assessment year is 2021, my lord.
Yes.
Your lordship, the professional, the interim resolution professional was appointed on 16/3/21, and due date for filing the return of income was on 31/5/21. But even though this professional was appointed, they have not filed the return of income for the period under consideration. Your lordship, this reassessment proceedings have been taken up on the, because of the reason RMS in the portal, RMS non-filing of return. Even though the transactions amounted to more than 9 crores, they have not filed the return of income, but they have filed the GST returns.
Correct, but then in the plan, you may have to keep your rights open.
Yes,
or now contingent liability that may come in future.
Yes,
now liability is crystallized as on that date, after which you can't. You file objection, let us.
May one submission with your lordship permission. Sorry, madam. I'm circulating just one judgment, but I'm troubling, madam, but madam, it may be settled here also, madam. Like madam. Wasan. Other three, four high court judgments are there, madam, but madam, I am circulating only one just to madam, because of time constraint. No, it's an admission matter. In this judgment, madam, even criminal liabilities done by the S12 promoters, directors, madam, will not follow, madam. Because madam, now, madam, I am appearing in another matter, madam, for the matter, madam, where PMLA has attached the property pursuant to the income tax proceeding. That also, madam, will not affect the successful bidder. Who is the different person, different management. Here, madam, here the Kaveri Medical Care is the different management and madam, new management. They are not connected. They are not related party. But in Dishnit, which is related by the assessing officer, that is the new same management.
I'll consider interim prayer. Let them file their state.
Till such time some interim order.
The counsel for the petitioner submits that the resolution plan had been approved and there was a confirmation of the liability of Yashovamati hospitals. Full stop. Further submitted that in light of the same question of resorting to 148 proceedings insofar as the subsequent purchaser.
Yes. Who is a different management?
Under a different management would not arise. full stop. Matter requires consideration. In the interregnum, there would be stay of
Annexure L and M, my lord.
annexure L and M. Statement of objections to be filed within 2 weeks.
3 weeks.
3 weeks.
Because my lord, the clarification is sought by DC-80. Here the AO is passing an order.
Let us see.
My name may be recorded, my lord, AG Satyanarayana, my lord.
Learned counsel so and so appears.
AG Satyanarayana.
AG Satyanarayana appears on behalf of the petitioner. Yes.
Number 16, Raju Channappa.
Date, my lord, 24th, my lord.
No, they let them file.
It's 24th July, my lord.
Let the pleadings be completed. We'll.
Remove the matter, remove the matter. Sanmati's client
Grateful.
doesn't accept dates.
I'm grateful, my lord.
Yes.
Your Honor, this is a GST matter, commercial taxes.
Yes.
Your Honor, in this is for the financial year 18-19.
M. Kumar, you accepted it?
Your Honor, in this, I'm challenging the jurisdiction of the second respondent who has passed the order, Annexure K, for the financial year 18-19, wherein he has no jurisdiction. He's an audit officer who has conducted the audit as well as passed the order under section 73. There is a preconceived bias, as well as he relies on an assignment issued by a joint commissioner. That is respondent number 3.
No, what is the point you're making?
The jurisdiction, I'm questioning the jurisdiction, Your Honor, wherein he has conducted the order adjudication proceeding under section 73 based on an assignment issued by joint commissioner, who in turn passes an assignment note based on the order passed by the commissioner. Under section 291, the proper officer is defined wherein a proper officer in relation to any function to be performed under this act means the commissioner or the officer of the state who is assigned that function by the commissioner shall pass is the definition of the proper officer.
Your KGST Act, is it?
Yes, Your Honor.
KGST. Yes. Commissioner or officer of the state tax.
Yes, Your Honor.
Yes.
Wherein the commissioner can assign it to an proper officer, junior to him under section 5(3) also. But here in Your Honor, the commissioner assigns it via annexure E at page 48.
Yes.
At page 48, here in this, Your Honor, the commissioner assigns it to a joint commissioner, admin. Adesha Sanke, below that, Your Honor, ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಕಾರಣಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಸರಕು ಮತ್ತು ಸೇವಾ ತೆರಿಗೆ 2017 ಪ್ರಕರಣ 5 ಉಪ ಪ್ರಕರಣ 3 ಅಡಿಯಲ್ಲಿ ಹಾಗೂ ಪ್ರಕರಣ 2 ಖಂಡ 91 ಪ್ರವರ್ತವಾಗಿ
Now joint commissioner is
in turn via annexure D at page 46.
Page
46, annexure D, Your Honor.
He further delegates.
He further delegates it to second respondent. That is Deputy Commissioner, Commercial Taxes Audit 24, DGSTO 2, Bangalore.
Page.
Your Honor, that is 40, the second assignment notice at 46, Annexure D.
You're saying this is impermissible.
This is impermissible. Subsequent to that, the person who has conducted the audit, who has issued the audit report, subsequently issues show cause notice under section 73. This is a preconceived bias.
No, that we'll see. No, but Hem Kumar, this may be a little difficult. Once under at one stage you can delegate it. The commissioner may delegate it to the person assigned by the commissioner. That assigned person cannot further delegate unless this power is.
What is delegated here, Malaj? The power to assign cases. Assignment is not given to the Joint Commissioner Administration. The power to assign is available with the commissioner or to the person to whom the commissioner would have delegated. A commissioner here has delegated the power to assign cases to the Joint Commissioner Administration. And he in turn, Malaj, he or she assigns particular cases to be taken up under section 73, 74 to particular office.
So it's not that he has assigned to the joint commissioner,
The power to assign cases is given to the Joint.
only the power to assign.
Yes.
Your Honor,
Not, first assignment is not given to the Joint Commissioner, then the Joint Commissioner does not transfer that assignment that is given to him to some other officer.
but Your Honor, my humble submission is the commissioner doesn't have that power to assign it to joint commissioner or give the power to joint commissioner to assign the cases. He under section 291, he himself has to assign the cases. And subsequently, Your Honor, under section 73, a proper officer suo motu can initiate the proceedings. Here, the person who has conducted the audit subsequently goes on to get an assignment from the JC admin based on an order passed by a commissioner of commercial taxes and proceeds to pass an order under section 73.
There is no power for that under Act.
Your Honor, it's a preconceived bias. The person who has conducted the audit subsequently goes on to pass an audit, pass an order of adjudication when he has already assumed or conceived to levy a tax, penalty and interest. He further goes on to issue show cause notice under 73 and pass an order.
Now, let us see. This is not an appellate, this question.
So, Your Honor, on the same ground, Your Honor, there is another WP wherein interim order is already granted, Your Honor. It can be combined, Your Honor.
Same SSC.
No, Your Honor, SSC is different, but the issue is same.
On merits, what is your case? On merits apart from this?
Your Honor, on merits, it's a difference between GSTR 2B and 3B, Your Honor.
And then we'll see if the circular applies, we'll see what is. We'll have it next week, examine it.
Please.
Irrespective of this jurisdictional point.
They don't participate in the proceedings before the adjudicating authority.
We'll see.
They don't file a reply. They don't go in for personal hearing.
Your Honor, personal hearing is never called for, Your Honor. In this, the personal hearing was never called for. Even asked.
Invited.
No, he has
Expert in the proceedings by filing a reply to the show cause notice as per a personal hearing.
No, let us see.
Instead of that, assist the
So if that
adjudicating
circular-
authority
Your
to
Honor,
go.
in the reply to the show cause notice, I've asked for a personal hearing.
Just one. Now you look at the circular and if it has to be sent back for reworking and circular applies, then we'll send it back.
Please.
When they open, leave open all contention. Have a look at the circular also.
Yes.
But I posted that similar matter on 25th.
25th. Deal is the matter, the same stage on 25th. AGA accepts notice for the respondents. This is circular, let us see.
Yes, Your
How these discrepancies to be dealt with. We'll send it back in terms of that circular if the circular applies. Have a look at it. Connected matter we put on the same date. Yes.
Your Honor, circular doesn't apply because it is below 5 lakhs. Here, the demand is around 76 lakhs.
No, both, that also is there. Further in the circular only, above that limit, there is some provision. Just
I'll
check.
I'll go through the circulator.
Yes.
17, Sandeep? Dilip?
Serial number 17, 65 and 68 pertain to the same SSC. Therefore, different assessment years, my lords. We've taken separate grounds challenging the assessment proceedings. But the common theme, if I may say so, my lords, is that I filed appeals against the assessment orders. They're pending before the first appellate authority. While no hearing has been conducted, they have attached my bank account and initiated recovery measures. So on the last occasion, when I made this submission, my lords, was request my learned friend to see whether a direction may be issued to the first appellate authority to dispose of the appeals in a time-bound manner. And subject to what my learned friend says, that may be.
6 months, my lords, we can dispose of the appeal before the commission.
That's they've attached the account. Let them just not recover the amount while the appeals are pending. That's my only submission.
So now 17.1.
65 and 68.
All,
Yes.
65 and
68.
Manjunath. 65 and 68. Now, these are for different periods.
Different assessment years.
So 17 is for which year?
Assessment year 1920 minutes.
1920. 17.1
is for two assessment years. Assessment years 1314 and 1415.
1314.
1415.
68.
Then
65, my lords, is for assessment year 1718.
1718.
And 68, my lords, is for assessment year 1890.
1819.
Please.
Only one submission, after attachment, we've already recovered about 44,000. That will be adjusted towards the demand, Manoj. We've already recovered.
The petitioner, all these WP 13941 of 2024, WP 12869 of 2024, WP 12792 of 2024, and 13125 of 2024 relate to the same SSC, and in light of the similar contentions raised, all these writ petitions are taken up together and disposed of by a common order. The writ petitions of the same SSC relate to different periods as follows. WP at serial number 17, assessment year 1920, 17.1, assessment year 1314, 1415, WP at 65, 1718, WP at 68, 1819. The petitioners in these writ petitions have sought for setting aside of the assessment orders for the relevant period, comma, computation sheet, comma, notice of demand, comma, penalty order, comma, penalty computation sheet, comma, penalty demand notice, comma, demand notices.
Those are the recovery
and,
notices.
Recovery notices. At the time of hearing of the matter, it is submitted that appeals have been filed.
Yes, pending in the first WP manner, pending before respondent number 4.
That's page 81, Manoj, with the acknowledgement.
Page
81, Manoj, Annexure K.
and are pending consideration before the Joint Commissioner Appeals.
No, Manoj.
That's,
Ah.
Commissioner appeal.
Commissioner appeals.
Before the Commissioner of Income Tax Appeals. Full stop. It is submitted that the grievance for the present arises out of attachment of the bank accounts, while appeals are still not disposed of. Full stop. Submitted that the grievance would stand addressed if the appeals are directed to be disposed of within a reasonable period. Full stop. Learned Counsel appearing to the revenue submits that partial recovery has been made pursuant to the attachment. And the same would be subject to adjustment depending on the final result of the appeals. Full stop. It's further submitted that the appeals in all these matters would be disposed of within 6 months from date of receipt of certified copy of the order. Full stop. In light of the stand taken by the revenue and the undertaking that appeals would be disposed of within 6 months, as noticed above, petitions are disposed of observing such stand by the respondent. All contentions on merits are kept open.
Till then, no recovery, further recovery. That will one out.
If already at COVID, there's nothing left.
The full demand has not been done.
Are restrained from taking further precipitative steps henceforth.
Attachment will still be intact. my
While
lords.
clarifying,
Please.
the attachment already made would stand undisturbed and be subject to final outcome of the appeal. Right, 16. What is this impleading?
What had happened, Manoj, in the two of the writ petitions, the appellate authority was not made a party. So for a formal purpose, we filed applications to implead the appellate authority.
In serial number 65.
Yes.
A2 of 24 for impleading is allowed. Learned Counsel Shri Dilip accepts notice for the proposed impleading applicant. Necessary amendment to be carried out.
Right.
That's only in 65.
And 17.1.
And
17.1.
17.1. Also, is it 17.1?
Please.
17.1, same order on IA for impleading. 17.1. Yes.
One submission, Manoj, the attachment has already been withdrawn. Manoj, I've just received, Manoj, it was withdrawn on 16th May 2024. Manoj, the attachment is, Manoj, we've adjusted about 44,000 and Manoj, we withdrawn the attachment. Manoj, what had happened, Manoj, the interim order
After
was-
adjustment.
Please, what had happened, Manoj, the interim order was passed, Manoj, that was not communicated to the TRO. Manoj, by then attachment was done, Manoj, we've recovered. So once the order was communicated, Manoj, we withdrawn the attachment. So the attachment is not, we withdrawn the attachment on 16th May.
Learned Counsel for the Revenue submits that pursuant to the attachment, there has been some recovery and such recovery would be subject to adjustment depending on the outcome of the appeals. It is further submitted that the attachment thereafter has been withdrawn.
Please,
Said
Manoj,
submission
16.
is taken note of.
Yeah.
Yes.
18, Suryakant, AG.
ಅದು ಎರಡು ಹಾಕಿ ನಾನು ಆಮೇಲೆ ಕರೆಕ್ಟ್ ಮಾಡ್ತೀನಿ ಮುಂಚೆ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ದು ಎರಡು ಇರ್ಲಿ ಆಮೇಲೆ ನಾನು
Petition.
ಕರೆಕ್ಟ್ ಮಾಡ್ತೀನಿ.
This issue is also pertaining to section 16(2) of 2C of the GST Act. That is the difference between GSTR 3B and 2C. The
Yes.
issue pertains to 2017-18. It was made mandatory only in 2022. It is not, applicable for earlier period. Rule 36(4), my lord, may kindly be taken. It has been clearly mentioned that it is only with effect from 1/1/2022, my lord. So it is not applicable for earlier period.
So what are you challenging?
It is challenging it is on 16, annexure D, my lord. That is order under section 73. And also the section is also under challenge. Section 16(2), because he can't deny the input tax
because of it is not reflected, because it was made mandatory only in 2022. Earlier, it was not there, my lord. The rule 36A clearly says, 36(4) clearly says that is only with effect from 1/1/2022, my lord. And similar matter, my lordship, my lord has granted the interim order. Annexure D is the impugned order, my lord. D and E.
Yes.
I
Can-
notice on behalf of respondents 2 to 4.
Learned Counsel M. Kumar accepts notice for respondents 2 to
4.
1.
One, Union of India. Union of.
Union of India.
Learned Counsel Jeevan
Union, yeah. Union.
accepts notice for the first respondent. He submitted that there is an interim order passed wherein in WP 14703 of 2023.
Yes, 1470.
wherein identical question is raised. And this court in WP 14703 of 2023 has referred to the interim order passed in WP 4743 of 2023, which reads as follows. Accordingly, on the ground of parity, there would be interim order of stay of
Annexure D, my lord.
Annexure D.
D and E, my lord.
D and E, subject to the petitioner depositing 10% of the
Tax amount.
tax amount.
4 weeks.
Period of 4 weeks from today. This matter along with WP 4743 of 2023.
Please.
Yes.
19, Ravi Shankar, SP.
No, this petition we are in challenge on annexure A and A1. If you are honest, we have to take to page 47 euros. Annexure A. In this case, what has happened is 2 officers have issued 148AB. The first notice being by a non-jurisdictional officer. And at A1, page 51, it is issued by the jurisdictional officer who has continued and then the order has been passed. Short point is the notice under 148AB by the jurisdictional officer at annexure A1 is again less than 7 days.
Is less than 7 days.
Yes, please. Issued on 6/3.
Pursuant to A1 148 AD is passed.
Pursuant to A1 148 AD is passed. Though annexure A is there issued by a different officer, but the jurisdiction does not lie with Ward 521. It lies with assessing officer 311.
Yes.
Tirumala should be the officer.
Lord, sir. We'll have it next week. Take instruction that 7 days we have to set it aside.
Please.
Okay. Yes. You want, we'll have it on Tuesday.
Yes, sir. I leave it here. 18th or 19th.
18th.
Please.
Learned Counsel Tirumalesh accepts notice for the respondents. Relist the matter on 18th. Yes.
The next case is an ex parte order. 20. School number 20. In this case, again, there are 2 notices, but it is issued by the same officer. I just want to pass over one document here. This is a sanction which you obtained by filing an RTA application, which may be placed on record. I'll file a copy with the, I think Sanmati would be the 150 sanction. We are only praying for a remand in this case, but the 151 sanction is unsigned. We obtained it by way of an RTI. So I will serve copies and your honors can take it next week. It can be disposed of for remand. I leave it yours.
Sanmati accepts notice for the respondents. Copy of the sanction order.
Along with petition.
A copy of the approval under 150 under Income Tax Act is placed on record, same placed on record. Reads the matter in the preliminary hearing list. On 25th.
Obliged.
21.
My lords, this is against the levy of service tax on a contractor.
Yes.
So petitioner, my lords, is a contractor. He constructs only road, building and other things. For earlier period, my lords, they have, after initiating the proceedings, they have dropped the proceedings on the ground that he falls under the exemption list notified under 25. For the subsequent year, my lord, subsequent periods, it's levied on the ground that I have not furnished certain particulars. Only on that ground. Last time, last occasion, the honorable court directed me to furnish the details so that it could be sent back. I have prepared the entire details. And even there is a finding in the order itself, my lords, it's all road construction only.
Week after next month, just examine this. No, I received this.
Yes, release the matter in the same stage on
My
26th.
lords, there is already finding in the order itself at page 93 onwards.
26.
Because they say that it's all construction of road in all the findings. And only on the ground that I have not furnished the contract certificates. That's the reason they have not allowed this. And there was a direction to me on the last occasion that you just to file it so that the matter could be sent back to the.
Just point out the observation in the order.
Page 90, ink page 93, my lords. 2000, table 6, they say that, my lords.
Yes.
Financial year is 2015-16. At the last column, my lords.
Yes.
They say nature of service provided as per documents produced and decision thereon. The first one, my lords, upgradation of balance road at Attibele Industrial Area, Bangalore related to transactional documents produced in allowed. This is allowed, my lord. Subsequent claim to be upgradation of balance road at Attibele Industrial Area, Bangalore. Proper related transactional documents not produced, hence not allowed.
So these are the documents for that.
These are all the documents, my lords. And there is clearly, it's all relates to road building or which is in the.
Then we can send it.
Just my lord.
Release the matter on 26th in the same stage. The
Can be disposed of.
memo along with documents with respect to disallowance of payments of the respondent on ground of non-furnishing of supporting documents placed on record. Same is taken note of. Yes.
26.
22. Syed.
For the petitioner, my lord, in this case.
Yes.
It's an ex parte order, my lord. Service tax demand, my lord, is raised for the period 15-16, 16-17. After I received, my lord, the show cause notice, I appeared before the officer and I undertook to produce documents, my lord. In the month of December, I fell unwell, because of which I could not appear and produce those documents. An order has come to be passed. My lord, for the period 15-16, the order, my lord, is now based on my income tax returns in Form 26AS, which I filed before the income tax authorities. My lord, the total income which is reflected, my lord, in the income tax returns includes not only services, income from services, but also income from goods which I have sold for that year. So that the order, my lord, may not be correct because it also includes that component, which is income from goods. For the subsequent year, my lord, 16-17, I have performed services for the state government, which is exempted under a notification. If I'm given an opportunity, my lord, I'll be able to place all these records before the authorities, my lord, and these things. So therefore, I'm only asking for a remand. I may go back to the authority and give all these documents.
Yes,
I have next week, my lord.
release the matter in the same stage on 19. You make one page note, we'll dispose it on the next once he
Please.
verifies. Yes,
23.
For the petition is matter pertaining to 16.4, my lord, of the CGST Act. So the Annexure C and D are the impugned order. Similar matters, this court has granted interim order. That is 16, but because the returns, the input tax has been delayed.
State or central?
Central. It's a central tax, G1 is appearing. Also the copy.
Grant council, G1 is directed to accept notice from correspondence
We do.
1 to 3.
2 and 3.
It is submitted that in matters raising identical legal issue, this court in WP 13330 of 2023, referring to order passed in WP 397 of 2022, has passed an interim order which reads as follows. In light of the same, there would be an interim order of stay
Annexure C and Annexure D, my lord.
of the order at Annexure C
Annexure D, my lord.
and D, subject to the petitioner depositing
10% of the
10% of
tax
the
amount
tax amount
in 4 weeks.
as assessed by the authority by the order of adjudication within a period of 4 weeks from today. List along with WP 3997 of 22.
Please.
24. Rajiv.
Your Honor, this is a service tax matter, central tax. Jivan Niralgi is already been served, Your Honor.
What is?
Yes. Yes, what is the question?
Your Honor, in this, the order is passed without considering my reply to the show cause notice and no personal hearing is been granted.
No,
Personal hearing is being granted.
74-5.
No, Your Honor, this
No,
is service tax matters here.
Service.
24-5 is now present GST. That is an intimation of tax liability. Oh, this is service tax, I believe.
Service tax, Your Honor. And the petition.
My lord, that service tax, third party information, I think, my lord, they have proceeded.
They have proceeded on the.
Before the proceeding on the basis of 26 years of the petitioner. I think he did not respond to the show cause notice, my lord, they have proceeded.
No, Your Honor, I have filed my reply to the show cause notice that is mentioned at.
It is based on 26 years.
Yes.
The lordship can in connected matters, similar matters, my lords have already granted that interim order. I don't know whether that's what it.
I don't know. But Your Honor, I am seeking to be remanded back because my submission to the show cause notice is not has been considered. At page number 21 of the order, discussion and findings,
It's based on 26 years. Huh?
it's based on 26 years. But he's not a registered service tax provider.
Or it is based on 26 years. My lord, if it is based on third party information on the basis of the, my lord, the income tax returns of the, my lord, the petitioner. Lordships have already entertained the writ petitions and the interim orders have been granted. Tomorrow, I think matters are posted that connected. Matters. On similar lines.
Your Honor, in this, I would prefer it would be sent back to the.
Okay, give it, now find out later. Relist the matter. In preliminary hearing list on
19th, your lords.
19th. Then council G1 accepts notice for the respondents.
25, Sudhakar.
I beg to appeal for the petitioner, my lord. Only a mandamus is sought, my lord. The matter itself could be disposed of. Petitioner, my lord, is a society, my lord, private, my lord, running a private aided college, my lord. Representation was given to.
Just 1 minute. Education, the council will come because they're in the middle of it. Let somebody come. We are doing tax matters, so education, the advocate will come, we'll just.
Shaman,
You will take it.
My lord, the representations were given to respondents 1 and 2. The practice and procedure prevailing, my lord, is it has to be given through respondent number 3 in 3 sets. Respondent number 3 in turn has to proceed, had to forward, my lord, retaining his copy, has to forward it to 1 and 2, respondents 1 and 2. That he has not done, my lord, for the last 3 months. Only a direction is sought to respondent number 3 here in, my lord, to forward the copies of representations to 1 and 2. That's all is the prayer, my lord. It could be disposed of.
Lord, can I request for a pass over 2:30, my lord? I'll make my submission.
Instead of 2:30, my lord, your lordship may have it tomorrow.
And Council Shaman Thank accepts this for response 1 to 3. List the matter in the preliminary hearing list on. We'll have it on the education day.
18th.
We'll have it on the education day. 18th.
18th. Great.
26. Anirudh Karnataka.
Yes.
My lords, this matter, if my lords recall, I am not disputing the tax and interest. But my only request was to remit the matter back so that I explore the opportunity under section 80, which is a request to the commissioner to give me 24 months time to make the payment. And also, with all due fairness, I mean, they have given me ample opportunities. I have not availed of it, but there is some reconciliation also required. Therefore, I would request that the order be set aside and I be remitted back with one opportunity. If my lords want a time frame to be fixed, that also may be done.
Section
80. I'd also handed over some decisions also of the other courts.
What order you're relying on?
I'd handed over a compilation, my lords, just 2 decisions, short 5-pager.
Yes. Yes.
Yes, my lord. So in both those orders, I mean, they have remitted matters back to explore the possibility of section 80.
We'll send it back.
Lord, if they accept the order, then they can make an application under section 80 for installment.
Correct.
But if he wants readjustment of the amount itself or reconsideration of the amount itself, then your lordship will have to look at the order and see whether sufficient opportunity has been given or not.
No, my lords.
If that opportunity has been given, then he has to accept the order or my lord challenge the order under 107.
If my lords
PC page 34, my lord, of the order. Sorry, of the writ petition, my lord.
May I, my lords? I submitted on the previous occasion, my lords, that I am not disputing any of this. They have given me ample opportunities. I'm not disputing that. But whether I have had sufficient cause in not approaching the authorities is the question. Because at the relevant point of time, my lords, I pointed out that COVID struck. I had taken about 86 odd high-end cars on loans. And thereafter, my lords pointed out to me, don't.
No, now the order.
Yes, my lords.
No, we start with a clean slate every day. So I don't know what happened last time. So you have to start fresh every time. Annexure C.
Yes, my lord.
At page 30 is the order, isn't it?
Yes, my lord.
Yes, my lord.
So this order of adjudication.
Yes, my lord.
Is an adjudication order.
Yes, my lord.
So he says he's accepting it.
He accepts the order.
No, I'm not accepting.
He wants installment.
My lords, what has happened is, it was passed. They had given me the opportunity, but I was not able to appear because my accountant defrauded me. There were chits that I was paying into for payment of this tax. That person defrauded me. My bank loans for the cars.
Correct. So now.
So all I'm requesting is there is some reconciliation required. Between GSTR 1 and 3B, there is a difference. But I need to be just given an opportunity, just some time may be fixed if my lords want to do that. But an opportunity be given to me to reconcile.
No, there's a difference between section 80 and reconciliation.
No, I agree.
Now, in case you're seeking for reconciliation, see if that, that circular applies to you. Just Manjuna, circular. See if this applies to you. If this applies.
Difference between GSTR 2B and 3B.
No, there is not 2B and 3B. This is between 1 and 3.
1 and 3.
Because what has happened at the relevant point of time, I mean, only the accountants were taking care and then they defrauded me, my lords. I couldn't pay attention to that because COVID struck. That 86 car loan was very huge for me. I was after that for repayment. Now I've done that. I want to pay these taxes. But the determination of the tax, let me be given an opportunity to reconcile is all my request is.
Then on merits, it has to be remanded.
If my lords may see the show cause notice and the order, there is no change. I mean, it's the same.
Where is the show cause notice?
My lords may see page number 26 onwards.
No, now you make a case for remand, we'll remand it back.
Sure, my lords. Page number 26, if my lords see, is where the show cause notice commences.
Yes.
If my lords may come down to page number 27.
Yes.
At the last fag end para, issue 1, short payment of tax. My lords have that? On verification of tax liability declared in GSTR 1.
Yes.
And tax liability declared in GSTR 3B for the period so on and so forth. It's observed that the tax liability as per so and so is compared with the tax liability declared in GSTR 3B resulted in short payment of tax liability of so and so for the period so and so. Narrated below white table, therefore taxable person liable to pay the tax liability of so and so. Table A, table is abstracted. In view of the observations finding so and so, is liable to pay the aforesaid IGST, so on and so forth. If my lords now come up to the order, which my lords will find at page number 30.
Yes.
Page number 32 onwards, short payment of tax. Same para, same abstraction of the tabulations, and again confirmation of the same para again.
Now here
There is no particular finding as such. It is just the show cause notice cut and pasted several times over. That's all the order is.
These were ex parte, is it?
Because yes, no, in all fairness, I have to say they have given me opportunities, but I was stuck in some rut that I could not avail of those opportunities.
No, the opportunity is given at page 33.
No, but other than the opportunity, my lord, this cannot be called a quasi-judicial order because it is not speaking.
So what is GSTR 1 and what is 3?
I think my friends will be able to explain that better because I have not done procedures ever.
GSTR 1 and GSTR 3B.
All I know is that they are returns.
Those are all the forms that are prescribed knowledge, and I'll have to take the assistance of the officer to explain.
Now this
These
comparison.
are all returns.
The comparison and reconciliation, what is the scope of adjudication here now? He claims that there has to be some reconciliation. If given an opportunity, he will show the discrepancy. So this you have to just explain what it is so that we'll at least.
My lord,
make the-
GSTR 1 is outward supply statement, it seems, and 3B is
Monthly returns which are paid. On the basis of
monthly
which tax is
returns.
paid.
GSTR 1 is the,
Simply a statement of outward supplies in a particular month. GSTR 3B is where you declare the supplies, also the inputs, and then pay tax.
Adjust all of that and then pay the output tax.
There could be a reconciliation which is mismatch between what is the supplies which you have declared in GSTR 1 and what is declared in GSTR 3B for various reasons. That is what usually when what's pointed out. No.
that reconciliation they can make out before the authority. Then we could consider it.
Or there is a remedy available, my lord, he can file an appeal, satisfy the authority there.
If it is the.
In fact, personal hearing has been given, my lord.
We'll do one thing. Now, insofar as that reconciliation, you file a memo. This is the proposed reconciliation. We'll take note of it and then we can take note of it and then we can send it. You produce what according to you is a prima officer reconciliation. That we'll take note of and then we can send it back.
I can do that.
Produce it.
I can do.
When do you want it?
Next week, my lords.
Release the matter in the same stage on 19.
Let them, my lord, serve the memo in advance.
I'll do
my lord.
that.
I'll also.
I'll do.
You serve it in advance, let him also get instruction.
Sure, ma'am.
Yes.
Much obliged.
27.
The office objections are, my lords, the court fees, my lords, have paid the court fee.
Yes, Sanmati.
Yeah, my lords. I'm seeking a remand of the matter for the reason, my lords. The bank had credited 3 crores.
Let him come, let him come.
Kindly,
I'll pass over, let him come.
kindly.
Yes.
28.
The petitioner here in blood is carrying on the business and obtained a registration under the GST Act with effect from 17/3/2021. And regularly filing a returns. Under the GST 3B1, 3B, applicable taxes up to September 2022, my lord.
Commissioner of Commercial Taxes.
Yes. Thereafterwards, my lord, due to even register cancellation of registration seat.
We'll accept notice for respondents 120.
Learned Counsel M. Kumar accepts notice for respondents 1 to 3. You want it next week or what?
I think copy was put in next week. ಇಲ್ಲ. 2 copies have already served.
ಆಯ್ತು, ಬೇಡ ಬಿಡಿ. 2 weeks. Then my lords may have it after 2 weeks.
Yes.
It is not fair on Mr. Yogi Swami to say that because he's experienced for more than 10 years on this side.
I am ready to give a because sometimes what a file will be misplaced with the office of the Advocate General. I know, brother, very well.
Release the matter on 20, on 19th.
Please.
19th.
It has to start afresh. Give him a copy, let him start afresh. Yes.
29. Baswaraj GS.
For the petitioner, lordship.
Lord, here, my lord, 2 orders are passed simultaneously, Annexure A and Annexure G. 2 proceedings are initiated. We'll have to drop one of these proceedings. I've sought for instructions, my lord, yet to receive it as to which one of these proceedings we'll be dropping. Lordship may have it on 19th, my lord. Meanwhile, I'll seek instructions.
On?
There's an interim order. Take it on.
Interim order illa.
On?
Interim order is necessarily required. lordship. Interim order is
I have it on
necessarily required.
25th, my lord. 25th.
Release the matter. The same stage on 25th.
25th. Great.
Interim order earlier granted is extended till the next
Lordship,
date.
interim order not been granted, now it to be.
Not to precipitate.
Earlier
the-
direction for the respondents not to take precipitative steps is extended till the next date. Great.
Interim order.
Yes. Next.
30. Shankaregowda MN.
30, my lord, the
7.
matter had come up yesterday. Unable to seek instructions, that lordship may have it on the 19th, my lord. I'll make my
On?
On 19th, my lord, I'll make my submission.
19th.
19th. There's a question of
bank
jurisdiction,
attachment, my
whether
lords.
the
19th.
19th.
List the matter in the same stage on 19th.
19th.
My lords, what has happened is there is an attachment of the bank account. I need they has to be granted by this honorable court. So far the recovery is concerned.
We'll stay further recovery.
Already an application has been filed before the bank authorities. So the corporation bank, that is Haryana.
We'll grant a limited stay till the next date, let us see. The respondents not to take any further precipitative steps pursuant to the notice dated 5/6/2024 till the next date.
Then the
Counsel for the petitioner files a memo producing copy of form GST DRC 13.
he may be permitted to operate the bank account, my lords.
ಏನ್ ಬರ್ದಿದ್ದೀರಾ? Same is taken on record, full stop. Learned counsel for the revenue seeks a short accommodation. Till such date, there would be respondents are restrained from taking any steps for attachment of the bank account. Is the matter in the orders list on 19th. Yes.
31, Ravishankar SC.
Serial number 29, ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರಿ ಅದೇನು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಇವಾಗ ಗ್ರಾಂಟ್ ಮಾಡ್ಬೇಕು
Not to precipitate. ಮಾಡಿದ್ದಾರೆ.
I've extended.
Not to precipitate.
I've extended the same direction passed on the last time.
ಸ್ವಾಮಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಬೇಕಾಗಿದೆ ನಮಗೆ ಆನ್ ಗ್ರೌಂಡ್ ಐ ಹ್ಯಾವ್ ಸಬ್ಮಿಷನ್ ಫಾರ್
Council, this is not the etiquette. You have to learn how to make representations. Once the court has passed the matter, there ends the matter. You'll have to wait till the next date. Yes. Next.
31, Ravishankar. Case of a cooperative society, curious case where the SSE has surrendered one PAN, obtained a fresh PAN in 2015, and thereafter filed the returns. The department has initiated action on the old PAN.
Yes, income tax.
I'm Tirumalesh.
Yes.
In this case, I could not file any reply because the portal is not allowing me to. I have filed a reply with the AO. She says I cannot activate it. So all orders have been passed, but thankfully the mail ID was proper. So I could produce all these notices.
This is the first time, is it?
Please, yes, Your Honor, it's first time.
Lord Counsel Shri Tirumalesh accepts notice for the respondents. Relist the matter
25th, my lords.
on 25th.
Pleasure. 32, Ravi Raghavan.
The demand which was laws of IGST.
Same stage in fact. Yes.
This is a demand of IGST Milords made on salaries which have been paid to expat employees in India. So Milords, I'm a project office in respect of a foreign company situated outside India. Certain employees Milords have been deputed or rather have been deployed to function from the project office in India. I'm a foreign company. I have a project office in India. Milords, on the same issue for the subsequent, this is for the period April 2018 to March 2019. For the period, my lord, 1718 in my own case, my lords have granted stay. And this matter is seized off, the court is seized off this matter. In fact, there are other petitions also on the similar point, saying that, my lords, the issue is, my lords, on whether IGST, well, GST can be levied on salaries which are paid. Because, my lords, in terms of the Schedule 3, services between employer and employee outside the levy of GST. Schedule 3 of the GST Act. Services, my lords, which are provided by an employee to an employer are outside the purview, my lords. Activities, this is Schedule 3. Serial number 1. Activities or transactions which shall be treated neither as a supply of goods nor as a supply of service. Services by an employee to the employer in the course of or in relation to his employment. Therefore, my lords, the salaries which I have paid is in relation to the employment service which have been provided to me by these expats. So, my lords, on this particular issue, my lords, this particular court is seized of the matter. The entire case of the department is relying upon a Supreme Court decision in Northern operating in the erstwhile regime. That, my lords, is distinguishable in the present regime, my lords. That's the.
Learned counsel for these.
Similar matters
for the
have been stayed.
petitioner submits that in so far as the same petitioner for a different period. Matter is seized off by this court and the identical legal issue has been raised. An interim order granted. Interim order granted in WP 10847 of 2024 reads as follows. Light of the same, there would be an interim order of stay of
Give the adjudication order, my lords.
Okay.
Annexure A.
Order at annexure K.
A.
A and
At page 13.
proceedings pursuant thereto. Liberty is reserved to the respondents to seek for modification of this order upon filing statement of objections. And Shaman Naik accepts notice for the respondents.
Pleasure.
Yes.
33.
IFF for the petition. The matter pertains to the input tax credit on 16.4 similar with petitions, subject to payment of 10% of the tax amount.
Shaman Naik accepts notice for the respondents.
Serial number 23.
It is submitted that the legal issue raised in the present matter is subject matter of consideration in WP 20319 of 2023, in which an interim order has been passed on 31/5/2024, which reads as hereunder. Accordingly, there will be an interim order of stay of
Annexure B and C, Madam.
annexure B and C,
Subject
subject to the
10%
petitioner
of the tax amount.
depositing 10% of the
Tax amount.
tax amount within a period of 4 weeks.
4 weeks.
Honorable Counsel Shaman Naik accepts notice for respondent 1 and 2.
34. This petition is arising out of an order which we could not reply to a show cause notice. The assessing officer makes a disallowance without rejecting my books.
Without
Rejecting my books. He makes an ad hoc disallowance. We are only praying here that we remanded. I get 2 opportunities to file submissions. He says my creditors have increased, but my sales have also increased by 14 crores. And my expenditure, apparently when I am buying more goods, my expenditure will increase. I could not file my reply to the show cause notice. So a fair opportunity may be given, or 2 opportunities. I will file my reply. Let him issue a fresh show cause notice and then pass an order.
Counsel Shri Raviraj accepts notice for the respondents. List the matter in preliminary hearing list on
Can be next week, Your Honor, because
19th.
please ask penalty order, sir.
35? Ravi Raghavan? 35?
Challenging an order and appeal, my lords, Joint Commissioner Appeals. Because here he has dismissed my appeal only on the ground, my lords, that I have filed the certified copy of the order beyond the prescribed period of 7 days, and therefore it's barred by time. My lords, the provisions, my lords, require that I can file the appeal electronically. And admittedly, I have filed the appeal electronically in the portal. There is no dispute.
Within the time.
Within a period of 3 months. There's no dispute on that. There is a provision, my lords, which was there prior to the amendment in 2023. It said that, my lords, in cases where the appeal has been filed online, there is a requirement to produce the physical copy or certified copy of the impugned order within a period of 7 days. And if it is provided post period of 7 days, the date when it is actually filed will be considered as the date of filing of the appeal itself.
That has been amended.
That has been amended subsequently because there was a confusion, and the whole purpose is when the impugned order before the appellate authority has already been uploaded online, and I file the appeal online, the impugned order is also visible to the appellate authority. Therefore, when it is visible to the appellate authority.
Shaman Naik accepts notice for the respondents. List the matter in preliminary hearing list on 19th. Now it's only on this point.
It's covered also, my lords.
On 19th or 18th?
19th.
19th.
Right.
In all these matters which are covered, you just make 1-page note. I'll look into it and we'll dictate it.
Please.
36, Ravi Shankar SP. 36.
In this case, I am a cooperative society. I have appeared in assessment proceedings and stated that my gross bank transactions are only 90 lakh.
Income tax?
I don't know, sir, Tirumalesh, CIT 3.
36.
Yes, yes.
Yes.
He makes an addition of 4 crores. Though I have filed my bank account, when the gross totals, it comes only to 90 lakhs. I just take it honest to page 81. I have only 2 bank accounts. I have filed both my bank accounts. In fact, he reproduces it in the order also. Page 81, bottom of the page. If you notice, second column from the right, 96 lakhs 79,004. This is my entire total for the whole year. But in the order, they make an addition of 4 crores based on AIR information, which I don't even have. Then there is a duplication in the data also. I have extracted in the petition. For a moment, if you are honest, to take to page 30.
Is the matter on?
Can be 19th, Your Honor, because penalty orders will get passed, then I have to amend the petition and again make them also issue.
Is the matter on 19th in preliminary hearing list? So you're saying it must be sent back?
It must be sent back to de novo. They must give me data what it is they are relying on. 4 crores. My transactions are not there. My balance sheet has 2 accounts.
Get instructions, get instructions. Yes.
37. Mohan?
37.
Advocate is suffering through VC, man.
Your Lordship, I appear for the petitioner in serial number 37. My senior, Mr. Prasad Padanjpe, is currently before the Bombay High Court, Your Lordship. May I only request that the matter be kept at 2:30?
Okay, pass over.
Thank you, Your Lordship.
38. Naveed Ahmad. Sure.
The petitioner is a work institution lords. Thus, it has established a education institution lords in 2018. Lords, initially lords, they had lords up to 8 standard lords, 1 to 8. And subsequently, my lord, they sought for recognition, lords for 9 and 10. Lords, in 2021, lords, the recognition was withdrawn on the lords ground that the second respondent, a work board, Lord issued a letter to the education department saying that Lord, the permission of the work board is not obtained by the institution. Lord, without hearing us, Lord, the recognition was withdrawn. Lord, we approached this court, my lords.
No, you're running a school on your own property or property?
On my own property. It is a work property, my lords, and it is my own property.
Now, what is the relationship between you and the second respondent?
Lord, second respondent is a board. I'm a committee of the board.
You're a committee of the board?
Yes, my lords. I have been appointed by the second respondent for a particular term, my lords. On election, lords, I have been elected by the, my appointment is approved by the board, my lords.
Yes.
Lords, the work fact is very clear, my lords. Only for the alienation of the work property, or to acquire any work property, I had to seek the permission of the board, my lords. My lord, the petitioner, my lords, is a orphanage. Lords, it's the main object of the petitioner is, lords, to impart education to the orphan students, lords, and they are not basically the inmates of the orphanage, for which we provide, lords, the education. Lords, we wanted to have, lord, upgrade the education, give them the English medium school, English medium education. Lords, accordingly, lords, we have upgraded our school, lords, in 2018. Lords, got recognition. Lords, while taking recognition, lords, we have informed the board. But lords, look, we are taking the permission from the education department for running a school. Lord, that they have not, lords, said anything at that point of time in 2018.
That intimation is there?
Intimation is there, lords.
Annexure?
Lords, annexure, lords, I have produced it in the earlier with petition, lords. I was unable to get it, lord, because this order was passed, lord.
Correct. Now, on what ground it's sought to be revoked or revoked?
Lords, now, lord, earlier it was withdrawn. Recognition was withdrawn. I came up before this court. This court set aside, saying that hear them pass the order. Lords, on remand, lords, kindly see the impugned order now passed, lords, at page number 30. Lords, the operative portion, lords, start from, lords, page number 38. Lords, very cryptic order came to be passed.
Lords, I read, my lords, the points framed by the lords, the first respondent, page number 38, my lord, in the impugned order.
But is this not an appealable order?
It is not an appealable order, my lords.
Yes,
Lords, may I read the points, my lord, framed by the lord, the first respondent.
yes.
ಮೇಲ್ಮನವಿದಾರರು ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ವಕ್ಫ್ ಬೋರ್ಡ್ ಆಫ್ ವಕ್ಫ್ ನಿಂದ ನಾಲೆಜ್ ವುಡ್ ಪಬ್ಲಿಕ್ ಶಾಲೆ ಪ್ರಾರಂಭಿಸಲು ಪ್ರತಿವಾದಿಯು ಅನುಮತಿ ಪಡೆದಿರುವುದನ್ನು ಸಾಬೀತುಪಡಿಸಿರುತ್ತಾರೆಯೇ? ನಾಲೆಜ್ ವುಡ್ ಪಬ್ಲಿಕ್ ಶಾಲೆ ಮಾನ್ಯತೆಯನ್ನು ರದ್ದುಪಡಿಸುವಾಗ ಆದೇಶವನ್ನು ಸ್ವೀಕರಿಸಬೇಕೆ? Lords, kindly see, Lords, the reasoning given by the Lords, the first respondent, Lords, at page number 39. Lords, ಮೇಲ್ಮನವಿದಾರರು ಹಾಗೂ ಪ್ರತಿವಾದಿಗಳು ಸಲ್ಲಿಸಿರುವ ಕಡತದಲ್ಲಿನ ದಾಖಲೆಗಳು ಮಾಹಿತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಕಾಲಕಾಲಕ್ಕೆ ವಿಚಾರಣೆ ನಡೆಸಲಾಗಿದೆ ಹಾಗೂ ಕಡತದಲ್ಲಿನ ದಾಖಲೆಗಳನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿದೆ ಮೇರೆಗೆ ಕೆಳಕಂಡ ಅಂಶಗಳನ್ನು ಗಮನಿಸಲಾಗಿದೆ. ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗಳು ನಿಯಮ 5(4) ಪ್ರಕಾರ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆ ಸ್ಥಾಪಿಸುವ ಮತ್ತು ನಿರ್ಮಿಸುವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕನಿಷ್ಠ 30 ವರ್ಷ ಅವಧಿಗೆ ಲೀಸ್ ಡೀಡ್ ಪಡೆಯುವ ಅವಶ್ಯಕತೆ ಇದೆ. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಈ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಸಲ್ಲಿಸುವುದನ್ನು ಗಮನಿಸಲಾಗಿದೆ. This is not the Lords, the objection from the second respondent. Lord, this is my own property. Why should I give Lords lease of 30 years?
This property belongs to the.
It belongs to the petitioner, Lords. It is a work property. Lord, the third, Lords, the reasoning. ಪ್ರತಿವಾದಿಗಳು ನಾಲೆಜ್ ವುಡ್ ಪಬ್ಲಿಕ್ ಪ್ರೌಢಶಾಲೆಯನ್ನು ಪ್ರಾರಂಭಿಸಲು ಇಲಾಖೆಯಿಂದ ಅನುಮತಿ ಪಡೆದಿರುವ ಬಗ್ಗೆ ಮೇಲ್ಮನವಿದಾರರಾದ ಕರ್ನಾಟಕ ವಕ್ಫ್ ಬೋರ್ಡ್ ಇವರಿಗೆ ದಿನಾಂಕ 30/7/18 ಪತ್ರದ ಅನೆಕ್ಷ ಬಿ ಮೂಲಕ ತಿಳಿಸಲಾಗಿರುತ್ತದೆ ಎಂದು ಆಕ್ಷೇಪಣೆ ಹೇಳಿಕೆಯಲ್ಲಿ ತಿಳಿಸಿದ್ದು ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿದಾಗ
Just point out, permission of the Waqf board is required with respect to what aspect?
Not at all, Lords. Let them say, Lords, let them produce a single provision to say.
No, according to you, it's required only for alienation.
For alienation, Lords.
Section?
Lords, section 58, Lords.
Waqf Act.
Sorry, not 58, Lords. I'll just. Lords, it is, my lords, Lords, 51, my lords. I'm sorry, my lords. 51.
Now, to show that this is your own property, any reference is there?
Lords, it is notified work property that is not at all in dispute, my lords. It is notified by the board itself.
Let us see, we'll consider it, let us.
No, yesterday they could do it. The state is a party. Lord, the director of secondary education is a party, my lords. State is not a party, my lords.
Serve a copy, we'll have it tomorrow.
But we already served the copy, my lords. Kindly see the my lords, the court copy, my lords. They have acknowledged the my lords, the receipt, my lords.
You've seen 12th fail, no?
Lords, I'll give once again, my lords.
No, you've seen 12th fail.
Lords.
So once again, you have to.
I will serve once again.
You give a copy, we'll have it
I will
tomorrow.
give it
Tomorrow.
Tomorrow. That means.
Relist the matter tomorrow in the preliminary hearing list.
Obliged, lords.
So the one they're saying it, the property belongs to them.
Yes.
If that is there, then this lease is not required. 2, according to them, under the Waqf Act, they don't require to get permission except where they're selling property, etc. So we'll consider the interim prayer, we'll see on them.
Obliged, lords.
You just point out that
I will, my lords.
any other provision
Yes,
relating to permission to be taken.
I will, my lords. Obliged.
Yes.
39, Sarvana, yes.
Seeking revaluation, RS3 students.
39.
There are RS3 students, they have taken up exams. Lordship, if you lordship have to see at page number 13, I've produced a tablet.
Let them take notice.
But the other matters are listing on 18th.
18th.
18th. This matter could also be taken on 18th.
Who accepts?
Farah Fatima, yes.
Farah Fatima is directed to accept notice for respondents. List the matter on 18th. Yes.
Order, sir, 40 urgent, 41, Mahesh Arupin, 41.
Yes.
Issue is of 2015-16, my lords. Petition is a PWD contractor. Focus notice was issued based on the third party information, my lords. However, the 4 notices were sent for the personal hearing. Petitioner did not appear, my lords. Their contention is that they are exempt from service tax. They haven't taken the registration as well.
But is it a fact that they're exempt?
Yes, my lords. That we'll have to verify with the documents, my lords.
We have the document that has been submitted before the appellate authority. The appellate authority did not consider it.
The department's contention is that they have not submitted any documents to show that they are exempted. Matter may be remanded back to the original authority, my lord, so that the documents may be verified.
Yes, ma'am.
You have produced all the documents before the
Yes, ma'am.
appellate authority.
Yes, ma'am. With challenge the order, ma'am, passed by the respondent number 2.
The petitioner has called in question the correctness of the order in original at annexure A passed by the second respondent and the order in appeal passed by the first respondent at annexure D. The petitioner, it is stated, is a PWD contractor rendering contract service to government/local authorities. And it is asserted that the said activity is exempt from service tax. It is submitted that the show cause notice, though issued, could not be replied due to bona fide reasons. And the second respondent has passed an ex parte order holding that the service provided by the petitioner was liable to be charged under service tax and raised a demand along with penalty, late fee and interest. Petitioner stated to have filed an appeal before the first respondent and appeal came to be disposed of. Counsel for the petitioner submits that the appeal was disposed on without affording sufficient opportunity to the petitioner. Now, where is it recorded that you have not produced any documents in the appellate order?
It's in the final order, annexure D.
Annexure?
D.
But you had produced it.
Yes, ma'am.
So where is that finding?
Page 18, my lords, 25.2, my lords.
Page
18, my lords. 25.2.
Okay, even in the appellate, correct. Now, in the appellate order at para 8, page 30, there is an observation that you have not produced any documentary evidence. But where is it that you have produced? You claim to have produced some material, isn't it?
Yes, ma'am.
Where is that you show? We'll refer to that and send it back.
Yes, ma'am. Kindly have it at 2:30, ma'am.
At
2:30,
Passover.
Passover.
Forty-two, yes.
I'm applying for respondent number 2, ma'am. Today's
For the
time,
petitioner.
2 weeks time for parents.
List after 2 weeks at request on behalf of the
Respondent number 2, ma'am.
respondent number 2.
43,
My objection.
43, Anand M.
My lord, your lordship had restored my GST registration and you had a clarification to be made that you will remit the matter back.
Just wait. Next matter, 1 minute, we'll wait. We'll take up the next matter. He said there is some order passed. 44,
44,
the petitioner said there was some judgment he'll produce. We'll pass over.
And also, my lord, there is a judgment, my lord, from Honorable Apex Court.
Huh.
To some more research on that, my lords, and my lord to seek some instruction also. The judgment says that, my lords, the Honorable High Courts are not supposed to interfere insofar as the condonation of delay, my lords.
Right, let's see this 44 will pass over, 43 and 44. Let's see what judgment he's relying on. Then I will accommodate. Pass over.
Your Honor, this is a GST matter.
45,
Yes.
Your Honor, in this, an order has been passed by Annexure H.
First
wherein-
time, is it?
No, Your Honor, this is, I've already have the interim order, Your Honor. It has to be sent back. They have not given me the opportunity of personal hearing. Wide section 74.5. 35.4, sorry, Your Honor.
Yes.
They have not sought for.
Your Honor,
He has not been granted. You have received the taxes. Matter can be remanded. You have got all the taxes.
75-4. 74-5.
No, 75.
4.
75-5. 75-5 is that 3 adjournment,
Three adjournments and 75.4 talks of.
personal hearing.
Personal hearing.
So where is the, will, at 2:30 will,
Able to demonstrate in the reply that they have sought for the opportunity of personal hearing.
Your Honor, I had produced an Madhya Pradesh High Court judgment wherein it is said, if an adverse opinion is to be taken.
whether
then
they ask
personal-
or not.
Whether they ask or not,
Hmm.
personal hearing should be granted. In this matter, Your Honor, before the show cause notice, the appellant accepted and paid the tax. But then after they issued a show cause notice wherein it was challenged. Then when the show cause notice had been challenged and have given a detailed reply, then they had to give me opportunity of personal hearing, which they haven't. And the show cause notice.
Point out in the order, 2:30. Just point out in the order reference to that personal opportunity. Mentioning at 2:30.
ಬರೋಣ 41 ನಿಮಗೆ ಮಾವು ಕೊಡಿ ಅರ್ಧ
Not one. My colleague is there from Delhi, serial number 74, my lord. But Sanpati sir also is here.
My lords,
Serial
serial
number?
number 74. Happy. My lords, I believe that the standing council has sought for an adjournment in this matter. My only request is that if a fixed date can be given in this matter, because otherwise it becomes a little unpredictable as far as listing is concerned, and council is to travel from outside Karnataka for this matter.
No, we have given a date, 3rd of July.
Third, my lords
3rd
is
of July.
okay, my lords, the instructions that I got was that it's been posted after 3 weeks. But if it
Yeah,
can be
but
taken up on 9th, my lords.
9th of July.
Much obliged.
Serial number 83.
And we would prefer outside council, you can come through VC because we are not sure physically if you come whether hearing will take place. We are comfortable with VC hearing also.
My lords, the only thing in this matter is that this matter can be disposed of because now the department has conceded. In the EL processing, they've conceded that the charge of EL is to be levied on these payments. So there is no further question required or adjudication required in this matter. That's why we moved this application that this matter can be disposed of.
No, then you file a memo for disposal.
We have filed an application along with the relevant order.
In fact, I have filed an
No,
application.
just one minute, just one minute. If it is so,
I will get instructions, not by
then you make a mention few days before the hearing that or you earlier itself, if that is so, you file a memo for disposal, get it countersigned by the counsel for the revenue who will take instructions. So ask your colleague to find out from him. Once he takes instruction, you move it an earlier date. I'll have it on top of the list and dispose. Yes.
Much obliged. Then I can probably move it for 26th June also, 23rd, 25th or 26th.
Let it come
After the revenue
Let them file memo first.
you file a memo, serve it on the other side. Briefly, why you feel it can be disposed of at this stage. Let the Sanmati get instructions. After that, we'll have it at an earlier date.
Yes.
Much obliged.
And interim order to be extended, my lord.
Yes, interim order.
Number 83.
80?
83.
Yes.
Taken next week. Next week. Any specific date maybe?
83. Release the matter on education
24th.
day. Education day.
24.
24.
Milord, serial
Inform
number.
the other side. Inform the other
This is
side.
the
Yes.
Milord, serial number 80. 80.
Yes.
Pays for 2 weeks time.
You inform the other side. At request. 80. But what is the exam then?
Exam, senior is not well, he'll be.
That is there, madam, but you should at least know, isn't it? What is the exam? Is there some urgency or
No,
not?
it's not, there is no urgency.
No urgency. List after 2 weeks at request. Yes.
Pass over matter, serial number 27. Mahesh Chandra BN. Mahesh Chandra.
Yes, Sanmati. Pass over.
37.
Milords, I appear for the petitioner virtually, Milords. Milords, am I audible?
Yes.
Milords, I appear for the petitioner in 37, Milords.
37, isn't it?
Yes, Milords, 37.
Commercial taxes. Kumar, you appear, is it?
I'll take note. It's a GST.
What about fourth respondent? Just show him
Give me a
the
copy of
cost
the petition. Just GST council, but Lordship, if I make a small submission, because that's the where, because we have challenged a particular notification. If I'm able to persuade Lordship on a remand of this matter at this stage, then we may not require presence of R4.
Yes.
Because the issue is very simple. I am in the business of Lordship food sale, and I operate out of Lordship 5 different states AP, Haryana.
Just 1 minute, just 1 minute. ಸ್ವಲ್ಪ volume ನೋಡು.
I will also speak louder, my lords.
Yes.
Lords, I operate out of 5 states of India: AP, Haryana, Tamil Nadu, Telangana, and one of the states is Karnataka.
Yes.
Lords, I file my GST returns and I discharge my GST liability in respective states, including state of Karnataka. Now, during the audit of my GST records in the state of Karnataka, a query was raised as to how have I paid my taxes correctly. I submitted them my details as to what are my turnover in different states, and therefore how my GST liability in Karnataka is correct. But in my respectful submission, ignoring my submissions of state-wise turnover breakup that I had provided to the audit authorities, as well as to the show cause issuing authority, and before the adjudication authority also, my entire all India turnover is sought to be taxed in the state of Karnataka. Despite Lordship, I have proven to them that I have paid taxes in those respective states where this turnover is reported in those GST returns. And very cryptic finding is, Lordship, given that SSC has not satisfied only on the ground that they found some miscellaneous differences in the turnover reported in my GSTR2 returns. And in any case, Lordship, the returns that I have disclosed before the GST authorities in Karnataka, those are on the higher side. Without giving any opportunity for me to explain as to if they had any grievances or if they had any queries on the data which I have submitted. But my submission is that if they could have given me up, because 99.88% of the total demand, Lordship, today is on account of this. So if Lordship,
let us see.
Yeah. Lordship,
We'll first ask them to accept notice and come back with preliminary instruction. We'll have it next week. Meanwhile, let them get preliminary instructions.
Yeah, Lordship, my request is if my learned friend can get instructions for remand of the matter, I can satisfy the authorities with whatever evidence they want to show them that my turnover in state of Karnataka is correctly reported in my GST returns, and therefore this matter should be re-adjudicated. Lordship. That's my request, because 99.88% of the demand is on account of this increase in demand because of this fictitious turnover being taken on record.
Let us see. Get instruction.
Lordship, no coercive action till then. Lordship.
What do you, they are seeking for some interim prayer. M. Kumar.
Please, Mona.
They're seeking for some interim protection.
Still next week, I don't think. I'll orally instruct the officer.
Yes.
Lordship would like to place it as a top on board or something so that it can be
Next week we'll formally consider. Meanwhile, he will instruct them not to take any action till the next week.
Now, I'm saying, Lordship, in the next week's cause list, can it be kept a little higher on the board so that it can be disposed of?
Let us see on the next week.
Lordship, would it be possible to keep it on Tuesday instead of Wednesday? I have some difficulty on Wednesday.
Yes, yes.
GST Council.
Relist the matter in the orders list on 18th.
Grateful. Grateful.
Consideration of interim prayer is kept open.
Grateful.
The M. Kumar accepts notice for 1 to 3.
Fourth Central Government Council, it's Jeevan.
Jeevan accepts notice for the fourth respondent. Yes.
Oblige me, Lords.
41, Mahesh 41.
Please give me copies. Get copies.
That's in this annexure C, we have mentioned to the respondent number 1 that we will produce the documents. The documents are not on record, but anyways, the documents are there. We will produce it before the.
That at least you produce it here, then we can send it back. You produce it here, we'll record that and send it back. You produce it here to demonstrate your bona fides, and then we'll send it back. When do you want it?
2 weeks time maybe.
Relist the matter. 2 weeks in the orders list on 2 weeks date. 3rd of July. Yes.
$43, Anand M.
No, 43, 44.
44.
So which is that order?
GST returns, my lord.
No,
I
no,
have
you
not
said-
filed the GST
Huh.
returns.
You said there is some judgment of the apex court.
Yes, my lord. As per the apex court, only this honorable court subsequently passed the order, my lord.
Huh.
I have furnished the two citations before this honorable court on 22/3/2024. According to this judgments, my lord, the same set of facts, 6 months delay for paying the invitation. Kindly see the para number 5 of the citations, my lord. As per the apex court citations only, this judgment was followed. As rightly contended by the learned court.
Just one minute, just.
I'm sorry.
Yeah.
Hmm? 44.
ಅಲ್ವಾ? ಅವ್ರು ರೆಫರ್ ಮಾಡ್ತಿದಾರೆ ಅವರು. ಅದು ಸಿಂಪ್ಲೆಕ್ಸ್ ರೆಫರ್ ಮಾಡ್ತಾರೆ.
Yes. Have you furnished a copy on him?
Yes. Oh, I have furnished earlier counsel, my lord. One Vanita Care, I have furnished all the citations also.
It ends
I
there.
think he is new
huh?
counsel. I will.
No, it ends there.
Yes, my lord.
It has to start with
Yes,
the fresh.
it is the para number 5, my lord. As rightly contended by the land counsel for the petitioners, though the first respondent appellate authority doesn't have any power to condone the delay in preferring an appeal under section 107 of the CGST Act. In the given case, it is open for this court to condone the delay by exercising its power under Article 226 of the Constitution of India. In the instant case, it is the specific assertion of the petitioner that due to untimely demise of his auditor and on account of the bona fide reasons, unavoidable circumstances and sufficient cause, it was not possible for him to not only file the GST returns and make payment within the stipulated time, but also could not prefer the appeal. Within the prescribed period. In my considered opinion, the explanation offered by the petitioners is not making GST payment, filing returns and preferring an appeal deserves to be accepted, and by adopting the justice-oriented approach, I deem it just and appropriate to set aside the impugned orders and to direct the second respondent to restore the GST registration of the petition subject to payment of all dues by the petitioners. The order portion. The petition is hereby allowed. The impugned order so-and-so is order passed by the first respondent is hereby set aside. The impugned order at annexure E dated so-and-so, their second respondent is hereby set aside. The second respondent is hereby directed to restore the GST registration in favor of the petitioners forthwith, without any delay. That's all the order. Because for avoiding the multiplicity of the proceedings, because anyway we will pay the taxes, my lord, all the arrears. Instead of sending him to remanded back to court and spending the time, it is loss or revenue to the exchequer of the government itself, my lord. Because it will delay 2-3 months, nothing else. Because better to revoke here itself.
Yes.
Other honorable court made us getting of judgments, no doubt about it. Court judgment number says the honorable high courts are not supposed to interfere when there is a delay. My lord, it's a conditional order, my lord. Has to be clarified and there are certain instructions that are received from the department. I have it next week, my lord.
Correct, but you take your stand, but finally, now they only want a restoration of the GST.
That's all, my lord.
So you, now they don't send them outside, they want to do business, they're ready to comply with conditions. So in that context, you have to take a broader view, unlike in other matters. Now, if we were to reject, where are they? They go out of business completely. That may not be the purpose of this provision, isn't it?
There is
So
one
take
more
a broad-
judgment. There is one more judgment, my lord, that is on dated 12th March 24.
Contrary.
Little, slightly, my lord, deviates from this. That is in, my lord, WP number 3688 of 24.
3688 of 24.
3688 of 24. Similar facts, my lord, but the operative portion of the order, my lord, slight, it takes a deviation.
Send it back, is it?
By remitting the matter back to the authorities.
But then that authority will say it's beyond my powers.
No. It has been sent to original authority.
To the?
Original authority, not to the appellate authority.
No, but if it is Beyond the
Now
period.
here, my lord, the appellate authority rejects the appeal on the ground that, my lord, he did not have a power to, my lord, condone the delay and entertain the appeal, which is filed beyond the statutory time. My lord, this honorable court has held that since the appeal filed beyond the period of a limitation is not an appeal in the eye of law, and the original order does not merge with the appellate order, and the High Court can, my lord, entertain an writ petition against the, my lord, the original order. On that premise, my lord, this honorable court entertained the writ petition and remitted the matter back to the original authority. So without, my lord, considering the, my lord, the appellate order as, that is the, my lord, 3688, that is the latest one.
You have a look at that also.
Yes, my lord. I will, my lord, ultimately what will happen, my lord, I cannot pay the tax, my lord, till revocation of my GST. Till it will delay the 4-5 months, except that nothing is remained, my lord.
Let us see.
So this, my lord, all the courts has restored the revocation here itself, my lord.
Let us see. Let us see.
Yes.
My lord, I'll
Post
also like to
conditions
place
and-
some judgments.
Kodi.
Even Chennai.
If it is remitted back, my lord, nothing.
Like it will make delay, nothing else, my lord. Because let him, it will consume the time, and till then I could not pay the arrears of the GST also, my lord.
Which paragraph?
My lord, kindly look at page number 31, my lord. 33, para number 6. Perusal of the material on record, including implement order, would indicate that inability and omission on part of the petitioner to file GST returns and so was due to bona fide reasons, unavoidable circumstances, and sufficient cause. In particular, the loss of income by petitioner due to prevailing COVID-19 pandemic. To state that the period prescribed for seeking revocation of cancellation by the petitioner and filing the appeal against the cancellation have expired in the special peculiar facts and circumstances of the instant case, and without making this order a precedent or having any presidential value or any purpose also, I deem it just and appropriate to set aside the impound order and restore the GST registration. My lord, even though it's not a precedent, my lord, just for reference sake, have produced this judgment. And here, my lord, if you look at the order, cancellation of GST registration of the petitioner is restored, subject to the petitioner paying entire up-to-date tax, including arrears along with interest within a period of 1 week from the date of receipt of a copy of this order, my lord. Lord, we are undertaking to pay all the arrears, my lord, along with interest.
Yes, anyhow, whatever instructions on the next date will decide.
Even though, my lord, without paying the GST revocation, my lord, without revocation, I could not pay the tax. They are telling, my lord, there is arrears again. Again, appeal.
19th. On 19th.
43 and 44. 45, Raji.
Yes.
So GST matter. Has to go back according to 95(4). Opportunity of personal hearing not given.
Manjuna. Other judgments, other the one will look at it, judgments. Another connected judgments. So where is the reference to in the order?
Your Honor, in the order, there is no reference. Reference is given to the Shuklas notice being replied filed.
Regarding personal hearing,
Personal hearing, there is no reference.
then you verify.
No, my lords, may kindly turn to page 123, my lord.
123.
The second paragraph, my lords. This is the reason why.
Yes.
That is the reason why the opportunity for personal hearing is not been granted. Because, my lords, upon the issuance of a DRG 1A in 73(5), the assessor has voluntarily discharged the taxes. May I read that, my lords? The reply is not considerable at this juncture as the taxpayer has accepted and already discharged tax liability voluntarily under 73(5) in response to series of opportunity afforded before issue of show cause notice, and therefore the interest calculated on the above observation to be so and so, and the remaining interest till date of payment is to be paid.
No, the only point remains that in case he has paid it under protest.
Your Honor,
He says, my lords, voluntarily paid.
Your Honor, may I make a suggestion? Once-
73.5 is self-ascertainment.
Well, 73.5 is an intimation issued in DRC 1A, wherein, my lords, if payments are made immediately upon issuance of DRC 1A, penalty will not be leviable. It will be only the tax amount and interest.
Now you have paid everything.
No, Your Honor, I've paid the tax amount. It was under protest. But they've got undertaking from the taxpayer that it is paid voluntarily. Then after they issue the show cause notice, once the show cause notice been issued and I challenge the show cause notice, then inadvertently they have to provide me the opportunity of personal hearing, which they haven't. And the show cause notice is dated 3/11/2022. I filed my reply on 22/12/2022. They have passed the order, Your Honor, exactly after 1 year. In between, they have not given me any opportunity of personal hearing.
No, now the point remains that no doubt he has paid it earlier, isn't it?
Please.
But after that, you still have issued a show cause notice on 3/11/22.
That is in under 73.1.
So that opportunity of hearing may still have to be given irrespective of the fact that he has discharged liability. We will send it back. This payment is earlier to the show cause notice.
Earlier. Upon issuance of DRC 1A. That is upon
The intimation.
The petitioner has called in question validity of the order in adjudication passed under section 73(9) of the KGST Act 2017, read with section 142 1A and 142 5 of the KGST rules 2017. Full stop. Petitioner has sought for quashing of form GST DRC 07 and order passed on 26/12/2023. It is to be noticed that the brief facts relevant for the purpose of adjudication in the present case is that the petitioner, prior to the order of adjudication under 73(9) passed on 26/12/2023, is stated to have voluntarily discharged liability pursuant to opportunity afforded, which payment it is asserted has been made prior to the issuance of show cause notice dated 3/12/2022. Pursuant to the show cause notice, reply was made out on 22/12/2022. However, in the order of adjudication, reply was not considered.
Your Honor, reply was considered.
Page 123, second paragraph. Reply was not taken note of by the authority by observing that the taxpayer had accepted and discharged liability voluntarily. Full stop. However, as rightly contended by counsel for the petitioner, once show cause notice is issued, matter becomes a disputed question requiring adjudication. Reply has been made out on 22/12/2022. Full stop. In light of the same, and also taking note of the mandate under 74(5), which requires opportunity of personal hearing.
75.
75-4, which requires opportunity of personal hearing to be afforded. If any adverse order is to be passed, it would be appropriate to relegate the matter to a fresh consideration from the stage of show cause notice. Needless to state, reply made out is to be considered and opportunity as envisaged under 75-4 be afforded and matter be disposed of as per law. All contentions are kept open. Accordingly, order at annexure H is set aside. The matter is remanded to the stage as referred to above. Yes.
Your Honor. May I have your attention? A date may be fixed for the person
Petitioner.
hearing, and then after time limit may be set, because already the time, this is a time barred this thing.
Once it is remanded, limitation will not arise, but if they want to appear on a particular day, they-
Petitioner to approach to appear before
Respondent number. Respondent number 2, Your Honor.
respondent number 2 on date Anjana, date appear 5th of July.
Much of
Yes.
Paper petition. Notes in serial number 46.6 million. This was a fresh pattern notes which was listed on item notes. Those are the instance of the college. Other matters notes have been tagged. In fact, those petitions notes are in fact not connected to this 46.6 million.
It has to be delinked, is it?
That's however, it was connected notes at the instance of learned counsel appearing notes for the college.
The petitioner in the case, my lords. My lordship.
That's in 46.6 million. 46.6 minutes.
It has to be delinked, is it?
Because they had sought for connecting minutes. They have to say minutes why the matters are connected. In 46.6 minutes, there is an urgency minute. I had pressed minutes for interim relief.
Who appears 46.6?
That's for the second respond college minute.
46.1, I am appearing for the respondent number 7.
No, just wait. 46.6. Who's contesting respondent?
On Friday minutes, MP Srikanth minutes, he had appeared on behalf of the second respond college.
His name is not shown.
They had appeared minutes and at their minutes, on their submission minutes, the other matters minutes, Lordship had directed the other matters to be tagged. Minutes, my interim relief minutes is as against minutes, the second respond college minutes, in not permitting the petitioners minutes to attend the classes of the 10th semester.
I'll pass over. You just call him. Pass over. Insofar as WP 6156 of 24, Third Counsel for the petitioner filed a memo which reads as hereunder. Light of the same is dismissed. WP 46 dismissed as dismissed. 46 is delinked and separate orders are passed.
46.5 also minutes. That is filed by me minutes. That is also that does not survive for consideration minutes because that is a repetition minutes filed minutes to permit me to attend the 8th semester classes. Now minutes 8th semester classes are completed, minutes are over. I have been promoted minutes to the 5th year, final year. And the interim relief and the final relief which was sought in the previous repetition minutes was to permit me to attend the classes and to write the examination.
Correct. All that is subject to orders to be passed.
There was no interim order passed by the Honorable Court. No. That repetition has become infructuous.
You file a memo at your risk, you can do it.
I'll withdraw my notes, filing a memo.
Counsel for petitioner in 46.5 has filed a memo which reads as hereunder. In light of the same, petition is dismissed. Yes, you bring him, we'll see. Yes.
My lords, My lords,
Yes,
I am for the petitioner in the 46.2. In the
we'll
same,
take it up. We're passed over. We'll take it up. Just wait. Yes.
But serial number 46.
In that 46.6, some urgency is there. He's gone to get the counsel appearing for the college. We have not, we have not taken it up. We have passed over and I'll adjourn it. I'll adjourn. On first, is it? Date note. Yes.
Senior has appeared through VC. VC. Karthik Rangan.
May it please, Lordship. I'm sorry, apologies. Item 47, matter came up last week. This is a GST matter.
Yes.
I think my friend Lordship has taken notice. A short issue, Lordship, for consideration is, Lordship, there are two forms that are usually filed, Form 2A and Form 3B. Lordship, this is a case where there is a mismatch, Lordship, between Form 2A and Form 3B.
Just 1 minute, we'll see.
Yes.
Akash Shetty. Let him come, let him come. Pass over.
Pass.
Yes, what is this matter?
Lord, the summary order was uploaded. The detailed order was not furnished to the petitioner. He then, my lord, files an appeal under 107. It is barred by limitation. But the detailed order, my lord, is served by hand much later. So he's within time. Let be, my lord, remanded back to the first of to the adjudicating authority itself. First appellate. Adjudicating authority. I'm sorry, my lord, first appellate authority.
Now, what is the period of limitation?
90
What is the
days.
limitation?
Limitation period is 3 months, my lord.
3 months.
Annually, it is served on 21/4/2023. And appeal is filed on 8/5/2023. So,
Appeal is filed on 8/5. Then the detailed order is furnished on
21/4/2023.
21/4.
2023.
So it is within 3 months.
Yes.
Summary of the order,
That is served on 16/12/2022.
16/12,
2022.
22.
Summary of order is not an order in itself, my lord.
Yes.
Summary of the some adjudication order.
The-
That adjudication order is applicable.
The petitioner has assailed. Order passed. The adjudication order dated 16/12/2022 has also summary of order. Petitioner also assailed the order in appeal dated 16/11/23 passed by the fourth respondent. It is the case of the petitioner that the order in appeal has dismissed, has resulted in dismissal of the appeal as being barred by limitation. Full stop. It is submitted that the summary of the order was served on the petitioner on 16/12/2022. Subsequently, petitioner has sought for issuance of adjudication order by request on 20th of April 23. And it is only on 21/4/2023. Respondent number 3 has issued a certified copy of the adjudication order passed under section 73(9), which is a detailed order. It is the case of the petitioner that such of the facts are not in dispute. And when appeal was filed on 8/5/2023, appeal was dismissed on the sole ground that the appeal was not filed within 90 days from 16/12/2022. 90 days. Full stop. If the period of limitation is calculated, it would clearly fall within the period of limitation prescribed, and accordingly, the appellate authority has committed illegality in dismissing the appeal on the ground that appeal was barred by limitation. The fact that a detailed order was made available to the petitioner on 21/4/2023 is not controverted. A mere furnishing of summary of the order would not result in period of limitation commencing. Period of limitation would commence as rightly contended by the petitioner from 21/4/2023. If that were to be so, appeal is filed within the time prescribed, as appeal was filed on 8/5/2023. Accordingly, the order of the appellate authority at annexure F is set aside. Matter is relegated to the Joint Commissioner of Commercial Taxes appeals for fresh consideration, and the appeal is to be taken up on file and disposed of in accordance with law.
That should be, instead of 90 days money, lots may say 3 months.
3 months, sir. 90 days.
To be filed within 3 months.
Yes. Yes.
And appeals, my lord, a date
Appeals
be
fine.
fixed, a date be fixed, my lord. A date be fixed in this to appear before the appellate authority.
We fix a date for your appearance.
Anytime.
Appellant to mark his
Issue the notice.
presence on 5th July before the appellate authority.
Great.
Yes.
Please, yeah.
Yes.
The only ground that raised is because the approval under section 151. Granted by principal chief commissioner. But reserve liberty, to initiate such, not able to dispute at this stage.
The present petition has been filed seeking for issuance of writ of certiorari to quash the notice issued under 148 capital A, B of the Act, as well as the unsigned sanction order at annexure A1. Petitioner has also sought for setting aside of the order under 148 capital AD at annexure A2, comma, notice under 148 at annexure A3, order under 147 at annexure A4, show cause notice of penalty at A5 and A6. The case of the petitioner that now this approval, the sanction is for notice itself,
Passing 148 AD order.
AD order. In the case of the petitioner, that 148 capital AD order cannot be passed without sanction under 151.
Please, sir.
It is submitted that the sanction that is produced at annexure
A1.
A1 being unsigned, the entirety of proceedings, including the 148 AD order and consequential proceedings instituted thereon, are liable to be set aside as being one without jurisdiction, as the absence of sanction goes to the root of the matter. Insofar as the sanction / approval under 151 of the Income Tax Act not being signed is not controverted. Accordingly, it would be appropriate to set aside. Now that A remains 148 AB remains valid only subsequent to that. Consequently, 148 AD order and further proceedings subsequent thereto, including notice under 148 at A3, order under 147 at A4, show cause notice regarding penalty at A5 and A6. Full stop. Further, in light of defect in the sanction accorded by an unsigned sanction order, annexure A1 also is set aside. Matter is remitted to the stage post 148 AB notice. The respondents are at liberty to obtain necessary sanction and proceed thereafter. All contentions are kept open. Yeah, Yes, yes.
Your Lordship, I would like to bring your kind notice to annexure H, Your Lordship. Okay.
Yes, can come up on the last rejection of from today under 190. Because that's simply there is an NRA and he is not aware of the income tax act, so he could not file the directed them to the document. That is the reason it was adjourned. Once it can be sent back, the commissioner consider
Your Lordship, I would like to bring a kind notice to annexure H, Your Lordship. In this case, order under section 119(2)(b), it's an unsigned order, Your Lordship. Section 282A of Act says that an unsigned order is not valid, your lordship, and it.
282, A2.
Yes, yeah.
What do you say A2?
Lordship, if I could bring you to page number 11.
Page?
Page number 11 of petition. I'll read out, your lordship. Section 282A, authentication of notices and other documents. Where this
Correct.
act-
What about 282A2? Subclause 2.
The notice or other document to be issued, served, or given for the purpose of this act by any income tax authority shall be deemed to be authenticated if the name and office of the designated income tax authority is printed, stamped, or otherwise written thereon.
In one of the cases, the department is contended, even though it's not signed. Under clause 2, name and is sufficient.
Digitally signed, your lordship.
At least.
Your lordship. It cannot go without a signature, your lordship. Otherwise, the validity of the order itself. There is no validity for the order, your lordship.
Now, since it's not signed, we'll send it back. And then liberty is afforded.
We have, your lordship, we have commissioner produced.
Record that, that
Give
we
it.
have not produced any document. That is the reason.
Could you?
We prepared a tabulation showing the passport entries of the passport, your lordship.
They can consider all this as a
You were not,
Lordship,
you
if
are
I
not
can-
in the country on the relevant date.
Yes, your lordship. If I can bring to you to page number 1.
Yes,
Serial number 3 and 4 of the tabulation, your lordship.
yes.
So the due date for filing of the return of income was 31/8/2015. The petitioner at that on those days had come to India, but he was not in Mangalore, your lordship. He had come for his business work in India on official duty. He had come to Hyderabad and then departed from Mumbai. And the seal of the arrival and departure is in the subsequent page.
Yes.
Page number 3. I have marked it as 3 and I have encircled it. That's the proof for his passport entries.
The petitioner has called in question the correctness of the order passed under section 119 2B of the Act at Annexure H. It is the case of the petitioner that the impugned order has been passed by taking a very hyper-technical view regarding aspect of delay. Though petitioner had taken the stand that he, being a non-resident residing in the United Arab Emirates, used to travel in and out and was forced to stay abroad for a substantial period of time during the relevant period in light of the lockdown imposed during COVID-19 pandemic. It is submitted that no sufficient opportunity has been granted to put forth his case. Full stop. Without prejudice to such of the contentions relating to non-appreciation of cause for delay appropriately, the counsel for the petitioner submits that the order under 119(2)(b) is unsigned. And on such ground also, order may be set aside and matter remitted for fresh consideration. Peruse the order at annexure H, which does not bear any signature, nor is it digitally signed. Full stop. It is also observed that the authority is taken a very conservative, and also that
Did not produce any documents regarding the passport. That is the reason.
and also taking note of the memo filed along with details of entry and exit of the petitioner between 36/2014 and 16/8/2017, as also the passport entries of the petitioner. It would be appropriate to relegate the matter for fresh consideration. Full stop. Next. Court has taken note of the documents produced by the petitioner before this court and feels and considers it to be appropriate to remand the matter back for fresh consideration. And while so considering the matter fresh, documents produced here may also before this court may also be looked into. Petitioners are also at liberty to make out additional pleadings and produce documents to substantiate his case for delay. Accordingly, the order at annexure H is set aside in light of the discussion made above. Matters remitted for fresh consideration. Petitioners at liberty to make out fresh further pleadings and produce documents in support of his case, which may be considered appropriately by the authority and matter be disposed in accordance with law. Accordingly, the order at annexure H is set aside and matter is disposed of.
Lordship, time limit may be placed, your Lordship, 4 weeks from the date of receipt of order.
The decision on 119(2)(b) is to be made within a period of
4 weeks from the receipt of order.
4 weeks from receipt of certified copy of the order. Yes.
Dilip?
May it please.
Yes.
Lords, in this case, the petitioner before my lords seeks my lord's indulgence in non-grant of refunds of close to 150 crores, despite the order of the Honorable High Court on 16th December of 2021. 16th December 2021, which is given in annexure A. Lords, this, despite repeated follow-ups thereafter, also no refund was granted. Then after filing this petition and before my lord placed it on orders, on 10th, that is day before yesterday, the tax and the refund as determined way back in 2022 has been refunded.
As on?
The lords may kindly provide. Take my lords to page 59 of the writ petition. In that, my lords will notice a table. In the table, my lords, several orders are there, about 5 years. The tribunal held in favor of the petitioner. In the second column, date of OGE, order giving effect, is mentioned, as my lords could kindly notice, starting from 25/5/2022, and it will go on up to 31/3/2022. Sometime in March, April, and May of 2022, these orders giving effect to have been passed, which my lords will kindly notice. A tax refund of 92.75 and interest thereon of 29.13 under 244A, subsection 1, clause B, was quantified to be about 121 crores. This has been given on 10th of June, that is day before yesterday. However, my lord, the point for consideration is, from these respective dates, once these amounts are determined as refundable,
The revenue could not have held on to that money till 10th of June. The section 244A1 within bracket small b would mandate even grant of interest in respect thereof. So therefore, my lords, there's only a part compliance with this. That apart, lords, under section 244A1A, another section apart from 0.5% interest per month, which will have to be granted under 244A1B. If, my lords, the revenue delays in granting refund post the appellate order, then there's an additional interest of 3% per annum has to be given.
244.
Capital A, subsection 1A. Lords, we find it at page 1.1243 on the right hand side. Or my lords referring to 2023 Act.
Yes.
Lords, we kindly go to 1.1243. On the right hand is the additional. Do my lords get that section?
Yes.
In a case where a refund arises as a result of giving effect to an order under various sections, my lords, hearing it is 254, order of the learned tribunal, wholly or partly, otherwise than by way of making fresh assessment or reassessment, the assessee shall be entitled to receive, in addition to the interest payable under subsection 1, an additional interest on such a amount of refund.
Yes, what do you say?
This fellow, there is a default.
We paid. Full stop. For the sake of the revenue. Relist the matter on 19th.
One more indulgence clause. In
Yes.
the order of the Honorable Court, my lords, on 16/12/2021, another prayer was granted that, my lords, a rectification application which was given as part of Annexure D to that writ petition, my lords, had to be passed within 6 weeks. That also has not been passed. So my learned friend may even carry it out before my lord the matter is brought out.
Let us see.
26.
26th. Release the matter on 26th.
52.
My lords, one small prayer. I have one more matter which is posted at 2:30.
Now we'll take it up.
Obliged.
Good man. Very long. 2:30. Other matters, I have a part-heard matter, I'll have to take it up. Other matters, dates will be given by the court officer.
Lord, item 56, your lordships have kept it today because the revenue wanted to seek instructions. Last week it had come up and your lordships have not granted interim order because the matter could be disposed. 56.
But it was only for non-consideration of the documents produced, it can be remanded to pass.
Tomorrow. 56 list, relist tomorrow in preliminary hearing list.
Grateful.
Lordship, may I mention item number 57, your lordship?
My lord, I have filed an application for amendment that may be allowed, my lord, subject to 52, my lord.
Application. ಪುಟಪಡಿದೆ. Application for amendment is allowed.
Original writ petition was quite challenging the notice issued under section 130, which has now culminated into an order. But my lord, this is one interim order that I would like to bring to my lord's kind notice.
We'll allow the amendment.
Yes, no, that may be allowed, my lord, let them file an amended writ petition.
Amendment application is allowed, necessary amendment to be carried out.
My lords, the goods are in our custody. It's an order passed under section 130. My lords, this honorable court, my lords, white order, my lords, dated 2/5/2024. My lords had said, my lords, the respondents are hereby ordered to release subject to the condition that the petitioner furnishes security to the extent of value of goods as stated in the invoice. Lord, till today, they have not come forward to furnish any bank guarantee. We may be permitted to take appropriate steps, my lords.
Your lordship may kindly see under section 130, 90 days is the time which is prescribed after the confiscation is concerned for release of the goods. That is one thing, my lord. Secondly, your lordship may kindly see, we have this, in this petition, my lords, various points have been raised. Right from challenging the validity of MOE 04 and detention order, and also the notice which was issued on the earlier occasion, and also the order on the ground that there is no jurisdiction at all, because your lordship may kindly see.
Let us see. We'll have it on 18th.
18th. Pleadings are complete, it has to be only taken up for hearing, because we had filed our statement of objections earlier itself, my lords, prior to the amended writ petition. Let them file an amended writ petition, my lords, then I'll see if additional issue has to be filed.
That will be given within 3 days, my lord.
Yes.
Can be taken up on 26th, my lord, for final hearing.
26th.
Your lordship, may I mention item number 57, your lordship?
Dates may be taken from the court officer.
Your lordship, may I mention item number 57, your lordship? Item number 57. Your lordship has already been considering.
Just wait. Yes. It's covered.
Serial number 60.
List the matter in the preliminary hearing list on.
Let's, I'll have to verify. Income tax matter, that was what I was wondering.
Tomorrow.
My lord, serial number 54.
Yes.
There's some slight urgency.
Hmm.
It's a constitutional validity issue. For interim orders, there's some slight urgency there.
Fresh matter.
Fresh matter, my lord, first time. Notice could be issued, matter posted on next Tuesday. We'll be obliged. Let them take instructions in the meanwhile.
Who appears?
I think Mr. Jeevan will appear and even Mr. Kumar will be.
We don't have the copy of the petition.
I'll serve the copies.
Just show the respondents, we'll say who will.
Yes. Respondents are. You can take.
I take notice for 1, 2, 3.
And 6,
1, 2, 3, and 6.
4 and 5 came Kumar.
4 and 5.
1, 2, 3, and 6. G1 accepts notice. 4 and 5, Hem Kumar. Consideration of entry place kept open. List the matter in the orders list on
Tuesday, my lord.
19th.
19th.
My lords, 19th, I'm not in station. 18th, if possible, my lords. If possible. Or even an earlier date, my lord, because they have some urgency. Even tomorrow, day after, any day. Even Fridays.
26.
Huh? 18th. 18th.
Deeply.
Your Lordship.
Deeply.
Your Lordship.
May I mention item number 57, Your Lordship? 57, Your Lordship. Your Lordship is already considering.
Dates you can ask. Dates you can ask from the court office.
Your Lordship, I may be permitted to mention a matter.
I'm only asking tacking of this case.
Your Lordship, may I mention item number
87?
57? 57, Your Lordship. 57, 57.
List in orders list on
19th.
Tuesday.
Your Lordship, may I mention item number 57?
No, so you ask the court officer, dates will be given.
59, no? 19th.
Dates will be given, you ask the court officer.
Your Lordship,
Lordship,
serial
in
number
item number
62, there is an
57,
urgency.
We'll repeat it. You take dates from the court officer.
Your Lordship,
You take dates. The court officer will give dates.
My lords,
Some urgency. An assessment order minutes for.
So when you want it, when do you want it?
27.
ನಾಳೆ ಕೊಡಿ.
Lordship, serial number 77.
Mark ಮಾಡ್ಕೊಳ್ಳಿ.
87?
So that's 56, my lords, I delivered it for tomorrow. Could it be under the caption? I'm okay with the next day also.
56. Relist the matter on 19th.
Under the caption.
Nale.
Is it possible?
Fresh matter.
But it stays pending on the last occasion. my lords,
Orders
I
list.
delivered it.
Orders list. My preliminary hearing list has become unwieldy. Preliminary hearing list. Yes, preliminary hearing list. Yes.
87? 87,
Your Lord-
Raviraj?
Your Lordship, may I
87?
humbly
You just leave a message in the chat box, or if your colleague is there, you ask. Dates will be given.
Your Lordship, I may be permitted to mention 62, Your Lordship.
No, correct. Dates will be given. Please take it from the court officer.
Your Lordship, in item number 57, Your Lordship has already granted interim stay in one of the similar matter. That's
Also granted in the same case. It's just the two different assessment ones, my lord, that's it.
We'll have it tomorrow. We'll have it tomorrow.
My lords, serial number?
Orders list. Serial number
57, my lord.
57. Orders
Your
list.
Lordship, mentioning of serial number 62, Your Lordship.
Which one? Serial number
77.
77. You want to rectify
Form IXB and D, Lordships.
77. 77.
File the wrong assessment here, form.
Yeah, makes a oral request to rearrange the annexures. Permission is granted.
My lords, serial number 64, 73, and 75, my lords. The matters against the deceased assessee, my lords, may be posted next week, my lords, Tuesday. And the interim orders be extended, my lords, in these matters.
64
73 and 75.
on same point.
Yes, my lord, same points. Order passed against a deceased assessee.
64, 73 and
75.
75. List in preliminary hearing list on 19th.
Interim orders may be extended.
Interim orders earlier granted are extended to the next date.
Grateful, my lords.
Your Lordship, a small indulgence with regard to serial number 62. Your
Just wait,
Lordship.
just wait. 58.
There is an attachment, Your Lordship.
No, Friday it won't reach. Friday it won't reach. It only Tuesdays on 19th. 19th. Yeah. Dates you can take from the court office. Yes.
Your Lordship, serial number 62, I appear for the petitioner. I seek an urgent relief. I need an interim relief in this, Your Lordship. If a date, maybe tomorrow if it can be taken up. 2:30 if it may be taken up.
Huh? 19th.
At 2:30.
So let us see. That day if it doesn't reach, you make a mention at 1:30. I'll tell you.
87.
Huh?
Document receive ಮಾಡಿ.
Yatish, yes.
You appear for the petitioner.
Document or return ಮಾಡಿದ್ರೆ documents.
You file a memo.
Please, ma'am.
Memo file. In light of the same, petition is dismissed as having become infructuous.
Lots have kept 88 also at 2:30 today.
After he's going to take some time. I'll keep it
I'll
in the
wait.
list and then we'll see.
11.
I'll
I'll
keep
wait.
it in the list if it doesn't conclude.
87.
Pilots. Pilots, I heard this on admissibility on the last occasion. If Pilot could kindly permit me, I will give a very brief recap of the issue involved in lots.
Yes.
Lots, this issue involves a case where Pilots, a search took place in one Nirav Modi's case. And thereafter, my lords, the search took place in the respondent's premises. During search, my lords, certain questions were asked and the statement was taken. No incriminating evidence of Nirav Modi was produced, nor anything was found in the premises of the respondent. The search went on for 3 days. In the peak of the night, a statement was taken, wherein, my lord, the respondent stated that she bought certain jewelries, precisely 3 items of jewelries, which she paid in check and recorded the same in a books of account. Over and above the check, she stated in a statement that she paid certain amount in cash. Together, it came to about 2.16 crores. Jewelry was seized, bank account was frozen. My lords, thereafter, the respondent retracted the statement, saying that during search either at Nirav Modi's place or at my place, nothing was found. The statement was extracted by exercise of undue influence. Nothing is there to establish all these statements are made. I am retracting the statement. And assessment proceedings were on. And under section 142(1), notice was made, during which point in time, the respondent again asked for the evidence. In reply to it, I will demonstrate to my lords a little later that a statement prepared by the computer sheet by the search party is given as if it were an incriminating evidence. Respondent objects to it. Before passing the assessment order, the respondent goes to the settlement commission. An application could be made before the settlement commission when a case is pending. Here is a case where it is pending before the assessing officer. The petitioner goes to the settlement commission. In the settlement commission, the petitioner makes a statement through an affidavit, which is given under Rule 8 of the Settlement Commission rules, stating that the respondent received gifts worth 2.2 crore over a period from 12/13 till 16/17. She gave year-wise details as to how much amount was received.
So the declaration is under Rule 8.
Under Rule 8. What Rule 8 says, my lords, in short, is that if I'll have to assert something which is not either borne on record nor is contrary to anything on record, same could be stated in the form of an affidavit. That is permitted by the Settlement Commission rules. Rule 8.
Contrary to record, because earlier
Nothing was found.
assessment was silent on this.
Assessment was not made, but the search did not unearth any incriminating document. There's nothing which was in the possession of the department except the statement of the respondent. So therefore, there was nothing available on record, neither in favor nor contrary to. So it could be asserted through the form of an affidavit in terms of Rule 8 of the Settlement Commission rules. This was objected to by the petitioner. It's called Rule 9 objection. The Settlement Commission hears both sides, records a finding that nothing has been found, by the department which is incriminating and accordingly settles the case by accepting the offer of 2.2 crores over a period from 12/30 until 16/17. This amount as such is not doubted, disputed by the petitioner. Petitioner does not dispute the admissibility of the application before the Settlement Commission. On the last occasion, my lords, I took my lords through 245C, 245D. Those aspects have not been doubted. The only grievance of the the petitioner, my lords, is that one particular amount of 61 lakh, instead of it falling under 16/17, it should fall under 17/18. Solely for the reason that in 17/18, there's an amendment increasing the rate of tax from 30% to 60%. The Settlement Commission, my lords, gave 3 reliefs, which I summarized on the last occasion. Relief 1, it accepted the affidavit of the respondent of 2.2 crores from 12/30 until 16/17. Relief 2, there was a valuation issue, which, my lord, the Settlement Commission held in favor of the respondent. Relief 3, the Settlement Commission is empowered, my lords, to grant immunity against levy of penalty and proceeding against on prosecution. That immunity also has been given. Out of 3 reliefs, the revenue, my lords, revenue appellant is concerned only with the first relief.
Yes.
Lords, the learned counsel for the petitioner submitted before my lords that the order of Settlement Commission is cryptic. The answer is no. I demonstrated to my lords, I read out the order of the Settlement Commission. The order is unreasoned, which is also incorrect because the Settlement Commission order is completely reasoned. And my lords, I was arguing before my lords on the very admissibility of the petition. For this purpose, I took my lords to the Vanchu Committee recommendation, which, my lords, the Vanchu Committee, headed by Justice Vanchu, recommended that in the case of errant taxpayers, once in lifetime opportunity has to be granted, where they come with a chest clean and offer the amount to the department or Settlement Commission, which has not been disclosed to the department hitherto, and Settlement Commission should be allowed to settle it. The Settlement Commission functions through the benches, headed by, my lords, the chairperson and the eminent members who are considered competent in the field of taxation and economics. So the Settlement Commission, as I have demonstrated to my lords, does not pass an order of assessment. It is in the nature of a compromise. It does a settlement. And the orders passed by the Settlement Commission in terms of 245I are final. It is not to say that my lord would not have jurisdiction to question my lords. However, the Honorable Supreme Court, I took my lords to the decision of the Honorable Supreme Court in Jyotendra Sinhaji versus SIT Party, paragraph 21-22, if I may just summarize, my lords, what the Honorable Supreme Court said is, in fact, the revenue in that case, before the Honorable Supreme Court, in para 21, argued that the Settlement Commission passes an order of settlement. It is a package deal. You take it or leave it in entirety. You can't question it on a truncated basis. And Settlement Commission is not bound to give reasons, is the argument of the revenue. And the Honorable Supreme Court in para 22, my lords, accepts these, and it would state that what the Settlement Commission does is a settlement. Number 1, my lords, it is a package deal. It cannot be questioned on a truncated basis. 3, my lords, you cannot venture into discerning the reasons behind the settlement unless the Settlement Commission gives reasons. Meaning, the Honorable Supreme Court gave its imprimatur to the argument of the Counsel for the Revenue that Settlement Commission need not give reasons. If at all it gives reasons, then only we would know on what basis had the Settlement Commission decided to settle the case. Therefore, my lords, the argument of the learned friend for the Revenue to state that the order is cryptic, order is reasonable, being incorrect on fact, would also be unacceptable in the light of what the Honorable Supreme Court has stated. Then, my lords, I took my lords to the decision of more latest decision of the Honorable Supreme Court, authored by Justice Nagaratna, my lords, Kotak Mahindra's case, which, my lords, has reiterated what was stated way back in 201 ITR. And it has been stated that the finality of the order of settlement commission should not be disturbed. Then, my lords, this Honorable Court, in N. Krishnan's case, also, my lords, brought out only under limited circumstances can the settlement commission's order be brought before the Honorable Writ Court. What are these? My lords, non-following the principles of natural justice, where the parties are unheard. Two, my lords, where the petitioner demonstrates that there is a particular provision of law which has been breached by the settlement commission. But, my lords, an error of law or an error of fact cannot be a matter which could be brought up before the Honorable Writ Court. If the petitioner is unhappy with the settlement, he has to be staying with the settlement. He cannot come to the Writ Court merely because he is not happy with the settlement. I would not burden my lords to take my lords through all those cases all over again. If my lords would permit, I may give a summary of arguments in the end, unless my lords would want me to take through those cases again.
No, just one.
Yes.
No, the summary will do.
Summary will do, my lords. Grateful, my lords. Then, my lords, if a settlement commission states something, unless a particular provision is shown to have been contravened, it is impermissible, my lords, for the petitioner to take it up as a challenge. And secondly, my lords, as I submitted, my lords, the piecemeal challenge is not permitted, which, my lords, the Honorable Supreme Court in Jyotinder Sinhaji 201 has stated. That apart, I took my lords to the decision of the Honorable Madras High Court in K. Veluswamy case, where also it is stated, my lords, that the truncated challenge is not maintainable. As I have submitted, my lords, out of 3 reliefs, the revenue is not concerned with 2 reliefs. They are only concerned with 1 relief. Thirdly, my lords, I submitted before my lords that the settlement commission itself is abolished. And in a decision before the Honorable Supreme Court in Action Global, according to the fact that the settlement commission is abolished, the Honorable Supreme Court chose not to entertain the special leave petition because it is all past, considered as settled. Settlement commission does not exist anymore. Why rectum?
But just tell me, under the litigation policy.
I'll take, my lord, the litigation policy.
CBDT circular.
I'll take to that, my lords. On the last occasion, I stopped when I took my lords to the national litigation policy, which my lords will find in, it is extracted in the decision of this honorable court in Ranka and Ranka. If my lords were to kindly take my compilation 1. My lords may kindly take page 52. The decision starts at page 52. And my lords may most kindly go to page 59. In paragraph 21, I took my lords through this national litigation policy as is extracted here. I read it out to my lords. It only expects, my lords, the government of India as not a compulsive litigant. Cases should not be fought merely because it is to be fought. The government has to be an efficient and a responsible litigant. My lords, an efficient litigant is defined, as well as a respondent, as well as a responsible litigant is defined. And at para 2 there, my lords, it stated that the government must cease to be a compulsive litigant. The philosophy that matters should be left to the court for ultimate decision has to be discarded. The easy approach, let the court decide, must be eschewed and condemned.
But is there not some circular?
I'll come
regarding-
to that, my lords. I've stopped here. Then, my lords, in continuation with this litigation policy, my lords, the Parliament enacted a section called Section 268 capital A, whereby it authorized the central government to keep coming out with notifications prescribing the monetary limits of tax effect, beyond which only litigation could be pursued by the government of India. Right now, my lords, before the Honorable High Court, it is 1 crore. But the point for consideration, my lords, is I would take my lords to the circular 17 of 2019. If my lords would kindly take in statement of objection at page 55, annexure R1A. My lords may most kindly take the statement of objection. Are my lords there?
Yes.
My lords will find it at page 55, where my lords will find at paragraph 2, the limit is 1 crore. However, my lords, this circular would say that it would not apply to the writ petitions, because this circular which I have given here would refer to in turn circular 3 of 2018, my lords, which my lords will find in page 57. In this, my lords, para 10, and particularly para 11, my lords, which my lords will find it at in my statement of objection, page 61. Do my lords find that? Para 11. There, my lords, the monetary limit specified in para 3 above shall not apply to writ matters. So this is the circular, my lords. It says monetary limit would not apply to the writ matters. However, my lords, this matter came before the Honorable High Court, my lords, the Honorable Division Bench of this court. In the case of CIT versus Dinakar Ullal, I would trouble my lords to kindly come back to my case law compilation. My lords, page 45, where my lords, the Honorable Division Bench of this court, at para 5, my lords, has held that the monetary limits will have to be applied even to the settlement commission. Para 5, my lords, may I read this, my lords? However, the contention of the Income Tax Department is that the monetary limits are not applicable to writ matters in terms of circular dated 5/2/2019. We are unable to accept this such submission. The writ petition has been filed by the assessee in view of there being no remedy provided under the Income Tax Act to challenge the impugned order under the provisions of the Income Tax Act. In the absence of an alternate remedy, writ jurisdiction was invoked. In case an alternate remedy was provided for under the Income Tax Act, in that event, an appeal would have to be filed, which would then be covered by the monetary limit. Only because an alternate remedy is not provided and the assessee was compelled to file a writ petition, the revenue cannot take advantage of it. Therefore, for the revenue to contend that they are protected by the circular in writ matters may not be correct. Therefore, keeping in mind the fact that the entire tax effect is less than 2 lakh, we do not find it appropriate to venture into merits of the appeal. Consequently, appeal is dismissed. Though it is in the context of a writ appeal, My lords, the Honorable Division Bench did not accept the contention of the department that the circular, though it states so, the court need not accept the circular. And the Honorable Court did not accept the submission of the department on the basis of circular and went on to hold that even the writ matters are covered by, my lords, the monetary limit. In the instant case, as I have submitted to my lords, the only contention of the revenue, my lords, is that 61 lakh of 1617 should be brought to 1718. My lords, the amount itself is less than 1 crore.
No, but what is the procedure? How are you treating the circular now? After the division bench order?
They continue to say so even now. Because in 2023, my lords, if I may answer my lord's question, in 2023, they brought out one more, my lords, the circular, wherein they retained the monetary limits. They have created some more exceptions. Like, my lords, there are situations of penny stock dealings, where, my lords, the capital gains artificially would be created to launder the money. The Panama leaks, which, my lords, the International Consortium for Justice, ICJ leaks, which are popularly called as Panama leaks. If the information received through automatic exchange of information about the possible leakage of revenue, these are some of the matters, and if strictures are passed against the tax officials, they've added some more exceptions, which inter alia would include, my lords, the writ matters also are excluded from the monetary limit. There is no doubt about that. In fact, my lords, that is why I submitted, my lords, in the beginning, without the aid of this notification, even without the aid of this notification, on its own, the settlement as such will have to be respected and cannot be, my lords, the drop of the hat be brought before the Honorable Court in a writ petition.
So it goes against the spirit of the litigation policy.
Exactly. Exactly, my lords. This is contrary to the spirit of the litigation policy.
Like not giving refunds.
Exactly, my lords.
Obviously, I'm troubled by this attitude sometimes. I'm saying that, yes, no, you come, you fight it out.
My lords, in many situations, the positions are taken in the field by the department that why would I take a risk? Even if there is a binding decision of the Honorable Court, let the matter be fought. Insofar as my circle is concerned, I should not be hauled up for any reason tomorrow. So this would be, my lords, though the Honorable Supreme Court in 55 ELT 622, Kamalakshi Finance, has stated that it is even impermissible for the tax official to say that the decision of the higher court is unacceptable, which itself, this saying itself is unacceptable. This is what the Honorable Supreme Court has said, my lords, in Kamalakshi Finance case. But the decision stays, the practice stays parallelly, of not following laws. So therefore, my lords, my humble submission is, my lords may not even have to get into merits of the case, which if my lords would choose, we are here to argue even on merits of the case. And this is simply not maintainable for all these reasons, my lords. And one last thing which I may submit, my lords, about what is found during search. I'll trouble my lords to some of these documents.
There's one aspect I want you to just.
My lords, I'm sorry.
What is the duty of the settlement commission?
What is the, my lords?
What is the duty cast on the settlement commission while considering an application for
Yes, my lords. I will take, my lords, to section 245D, subsection 4. Which my lords will find it at page 1.1257. And before that, I also took my lords to subsection 3. I'll read, my lords, subsection 3 and 4.
Yes.
The settlement commission, in respect of clauses 1 and 2, which may be ignored for a while, may call for records, which it did call, even though it is option, because the word may is used. And the Honorable Supreme Court, my lords, in Anjum Gasawala, 252 ITR 1, has held that the word may necessarily indicates a discretion, may call for the records from the principal commissioner or commissioner, and after examination of such records, if the settlement commission is of the opinion that any further inquiry in the matter is necessary, it may direct, only if it considers necessary. This also, my lords, in 444 ITR, page 1, the Honorable Supreme Court in Ashish Agarwal, in a similar situation of 148 capital A, within bracket small a, my lords, we're dealing with reassessment under the new regime. So this is a case where if he considers it necessary, he may conduct an inquiry. 148 capital A within brackets A. The Honorable Supreme Court said it is only a discretion. It is not a mandate to conduct inquiry. Such further inquiry or investigation and furnish a report on the matters covered by the application and any other matter relating to the case, and the principal commissioner shall furnish the report within a period of 90 days of the receipt of communication from the settlement commission. Provided that where the principal commissioner does not furnish the report within the aforesaid period, the settlement commission may proceed to pass an order under subsection 4. Lord, these are the plenary powers which the settlement commission has.
Here the report was called for or not?
Report was called for. Rule 9. Rule 9 report was furnished. Even calling for report, my lords, is not mandatory. No, my lords.
So there ends the matter according to you.
Now, my lords, subsection 4, which my lords had a question which I have to answer now. After examination of the records and the report of so and so, my lords, and after giving an opportunity to the applicant and the principal commissioner to be heard, there is no denial of such opportunity, nor is there any allegation in this regard. Either in person or through representative duly authorized in this behalf, and after examining such further evidence as may be placed before it or obtained by it. My lords, may most kindly allow me a pause here. Placed before it. So it is important, my lords, for either party who would want to assert existence of a particular state of fact to give the evidence. If the revenue miserably fails to give any incriminating evidence whatsoever, and if the assessee comes up with an affidavit, and if the settlement commission accepts it, no exception can be taken for this, because that is not found to be incorrect under law.
Unless the commission itself felt that
Exactly.
particular aspect or declaration required further investigation.
Exactly. Now, my lords, settlement commission may, now it is extremely important, in accordance with the provisions of this act, pass an order as it thinks fit on the matters covered by the application and any other matter relating to the case not covered by the application, but referred to in the report of the principal commissioner. So, my lords, may most kindly notice here that the settlement commission may pass an order as it thinks fit. This gives extreme latitude, my lords, to the settlement commission. However, such latitude so given is circumscribed by, my lords, in accordance with the provisions of the act. Now, my lords asked a question on the last occasion. What is the meaning of in accordance with the provisions of the act? My lords, in accordance with the provisions of the act, if I may submit, my lords, would mean that if the depreciation is only 15% under the act, settlement commission cannot give 20%. If the standard deduction, my lords, is only 25,000, it cannot give 50,000. So if there is a clear provision of law, tax rate is 20%, it cannot make it 30% or 15%.
So in its substantive order of giving relief,
exactly,
it must be consonance with what?
In consonance with the broad provisions of the act. But at the same time, my lords, it cannot be mistaken to be an assessment order. Because the Honorable Supreme Court has held that it's an order of settlement, it's not an order of assessment. Even while the settlement commission does so, my lords, may most kindly go to 245F. 245F, my lords. At page 1.1262. On the left-hand side. My lords, there. In addition to the powers conferred on the settlement commission under this chapter, it shall have all the powers which are vested in an income tax authority under this act. Meaning, my lords, as it does the settlement, it has all the powers. Why are the powers of income tax officer given to settlement commission? That is answered in subsection 2, which I read out on the last occasion. I'll just submit it to my lord. It says that once a case that is pending before an assessing officer is taken into the settlement commission, the assessing officer ceases to have jurisdiction. Settlement commission will have exclusive jurisdiction. He can do what all the assessing officer can do. Settlement commission may also go beyond what an assessing officer could have done in the spirit of settlement. And my lord asked a question on the last occasion about Order 23, Rule 3, where, my lords, the compromise of suit is stated. So we went through this, my lords, as directed by my lords. And if I may submit this to my lords, that the Vanchu committee says settlement is in the form of a compromise. However, my lords, it cannot be strictly treated as a compromise because the words in accordance with law and some of the bare provisions of the act cannot be compromised. Like I gave example, my lords, the rate of depreciation, the rate of tax, etc., cannot be compromised. So in that sense, it has to be understood, my lord, as the provisions of the law, which will deal with substantive part of it, not the procedural part, because procedural part of law would not apply to settlement commission. For example, as my lords have noticed, for a scrutiny assessment, it has to be kick-started with a notice under 143.2. There is a time limit for it. Then subsequent notices will have to be issued under 142.1. Then an order will have to be passed under 143.3. Or in the case of reassessment, my lords have noticed that 148A.B. notice will have to be sent. Then an order under 148A.D. will have to be passed, followed by notice under 148, then followed by a proper assessment. These are all the procedural part. These aspects are not applicable to the settlement commission because they are doing the settlement. However, a substantive part would apply. With this, my lords, may I take my lords through this Rule 3, Order 23. I'll just read this out, my lords.
CPC. The reason why I was drawing a parallel, perhaps it may not be appropriate, is that in case of compromises, it may not be in accordance with the law, but the settlement, as long as it is not opposed to law.
Exactly.
And agreed between the parties and maybe at variance with the legal determination, is still to be accepted because we are not sitting there to as a judge. So they may say his entitlement may be half. He may decide to accept 1/4. We cannot intervene in it. The only limitation is it should not be opposed to law in the sense against public policy.
In fact, what my lords have noticed and hence directed me to look into this Order 23, Rule 3, is resonated, my lords, way back by the Honorable Supreme Court, which decision was rendered before even I was born, my lords. 27 ITR 775, Dakeshwari Cotton Mills case. In the context of income tax, the Honorable Supreme Court said the technical rules of Civil Law and the Evidence Act and the CPC may not apply, although the spirit is to be applied. So therefore, my lords, although the settlement commission's settlement may not strictly fit into the meaning of the compromise, the spirit of compromise, which my lords have just now brought out, will have to be accepted, my lords, even as one decides whether settlement commission's orders is to be disturbed or not. So therefore, my lords, though as my lords have noticed, it may not fit into strictly a compromise, but the spirit of that may have to be applied. Now, my lords,
so this credit worthiness, etc., which they are canvassing, comes from where?
my lords, what my learned friend argued, my lords, is contrary to what, my lords, is the submission made by the settlement commission, by the petitioner in Rule 9. In Rule 9, the case of the petitioner is Section 69. What my learned friend argued the other day, my lords, is Section 68. What are these sections? These come in Chapter 6 of the Income Tax Act. They are called the rules of evidence. Section 68 says, my lords, if any cash is found credited in the books of account, and if the assessee is asked to give explanation for the source of it, if he fails to give an explanation, or the explanation which he gives is not acceptable to the assessing officer in the course of assessment, the cash so found credited in the books may be treated as income. My lords, here is a case where there is no books of account insofar as the alleged cash payment is concerned. I'll take my lord to section 68. So therefore,
Yeah, let me just go to rule 9 and come to 68.
yes, my lords. My lords may kindly take to rule 9 for a while.
The rules are separately annexed, is it?
No, rule is not annexed. The submission made by the petitioner is under rule 9. That is given, my lords, in annexure C. Annexure C of the petition, my lords, at page 51. This has been to some extent extracted in the order of the Settlement Commission. Now, my lords, para 3, purchase of jewelry in cash. There, my lords.
But what does rule 9 say?
Rule 9, my lords. I'll take my lords to rule 9 of the Settlement Commission rules. It is nothing much, my lords. My lords may kindly take income tax rules, where there is a separate column called Settlement Commission rules. I would not know, my lords. I'll just figure out whether in the volume which my lords is carrying, whether it is there or not. I'll ask my learned friend too. May I give this, my lords? Rule 8 is what, my lords, which permits either party to give through an affidavit what is not contrary to record. Rule 9, my lords, will find little below that.
That's a report by the commissioner.
Exactly, my lords. This is a report by the commissioner, which, my lords, he makes it to the Settlement Commission. I read out, my lords, section 245C calling for report. That's the report. So there is no, my lords, any defect even in the procedure. The decision, my lords, decision of the Settlement Commission cannot be challenged. If at all something could be brought to challenge the decision-making process.
Now, this 68 comes where into the picture? Where does it come into the picture now?
It is because my learned friend has argued for the first time before, my lords. Otherwise, 68 will not even come. Here, my lords, in the Rule 9 report in Annexure C, which I showed, my lords, they are talking about 69, section 69, which talks about unexplained investment, which also is not the right section. No, 1 minute. I would request my learned friend just allow me to complete. My lords, I was explaining to my lords the different sections. Now with this background, if my lords were to go to section 68 for a while, my lords will find it at page 1.515. My lords will find it at page 1.515.
Yes.
Here, my lords, cash credits, where any sum is found credited in the books of an assessee maintained for any previous year, and the assessee offers no explanation about the nature and source thereof, or explanation offered by him is not in the opinion of the assessing officer, is satisfactory. Sum so credited may be charged to the income tax or the income of the assessee of that previous year. My lords, I am taking my lords through this section because my lords asked me a question. The 3 factors, when are they relevant? The various decisions which the learned friend relied on, be it Mohan Kala's case, be it, my lords, the other cases on the other day, all are in respect of section 68. I will explain, my lords, what is section 68. Let us say, my lords, I am making some profits in my business. I want to reduce profits by booking expenditure, which is not actually incurred. What would I do? I will show in my books as though I have received some loan. get cash, because I get a loan and get cash, use that cash to book expenditure. So that is why they have brought in 68. If you have shown any borrowing, any sum found credited in your books of account, we will ask you, where is that creditor? Give me the trinity of factors. What are the trinity of factors? Identity of the creditor, genuineness of the loan transaction, and whether creditworthiness is established. For example, if I take from my lowly paid employee who is paid 25,000 rupees a month, a loan of 25 crore, identity is established. Transaction may have taken place through the check. Genuineness may have been established. Creditworthiness of that person could be brought into question. So those three factors are relevant only to section 68, which is not the section invoked at all. So I'm submitting before my lord that all my learned friend argued on genuineness, creditworthiness, and the identity are irrelevant to the point on hand. Here is a case where I have not received any cash. The allegation is I have paid extra cash. So 68 itself is not applicable. In fact, my lords, in the petition, my lords may notice, they are not even identified what a particular section is. They say 68 to 69. They give the range of sections. So the petition is vague. Doesn't even identify which section that would apply.
No, so their contention is that 68 should have been referred to by the settlement commission. That's what their contention.
Their contention is it is a case. Their contention is it is a case of 68. They should not have accepted the affidavit of the assessee before the settlement commission. Now, my lords, may most kindly notice here. I'll read this again. Assuming 68 were to apply for a while, what does the section say? Now, can you just? I'll come to 69. May I continue, my lords?
No, but what was running in my mind,
yes,
that the settlement commission, when is conducting these proceedings, is only governed by the 245, whatever.
245D4, that's all, my lords.
We can't go beyond that.
Exactly.
Though he may have had the power that's of the assessing officer, those are more procedural or only to indicate to what extent you can exercise the power.
Exactly.
But,
in fact,
but you can't say now it should function as a
assessing officer,
adjudicating
authority. Because even for a while, if my lords were to up any section, my lords may 68, 69, whatever my learned friend may want to place, take any section, my lord. What it says, explanation offered by him in the opinion of the assessing officer, not satisfactory. My lords may substitute assessing officer by settlement commission for a while.
It can't be done technically.
Assuming, my lords, what my learned friend says, assuming for a while, because it has all the powers of the assessing officer in terms of 245F subsection 1. Assuming for a while, settlement commission sit itself in the chair of the assessing officer. It is the call of that assessing officer or the so-called assessing officer. In his opinion, if it is found to be satisfactory, he need not make an addition.
There ends the matter.
There ends the matter. The sum so credited may be, my lords may most kindly see here, may be, the word may is uniformly found in all the sections, including section 69, which my learned friend would be arguing. And this particular word may came before the Honorable Supreme Court in 237 ITR 570, my lords. Noor Jahan's case. Lords, may kindly go to my compilation one. At page 77, my lords. Lords will find it at page 77. In fact, in the specific context of section 69. My lords, may I straight away go to page 78 at para 3. Page 78 at para 3. May I read this, my lords? One para may be permitted to be read. See, Ranbir Chandra, the learned counsel appearing for the revenue, has urged that the tribunal as well as the High Court were in error in their interpretation of section 69. The submission is that once the explanation offered by the SSC for the sources of investments found to be non-acceptable, the only course open to the ITO was to treat the value of the investments to be the income of the SSC. Submission is that the word may in section 69 should be read as shall. We are unable to agree, as pointed out by the tribunal, in the corresponding clause in the bill which was introduced by the parliament, the word shall has been used. But during the course of consideration of the bill and of the recommendation of the select committee, the word was substituted by word may. This clearly indicates that the intention of parliament in enacting section 69 was to confer a discretion on the ITO in the matter of treating the source of investment, which has not been satisfactorily explained by the SSC as the income of the SSC, and the ITO is not obliged to treat such source of investment as income in every case where the explanation offered is found to be not satisfactory. The question whether the source of investment should be treated as income or not under section 69 has to be considered in the light of facts of each case. In other words, the discretion has been conferred on the ITO under section 69 to treat the source of investment as income of the SSC if the explanation offered by the SSC is not found satisfactory, and such discretion has to be exercised keeping in view the facts and circumstances of a particular case. Lords, even if it were the assessing officer for a while, he also could not have made the addition, which I'll demonstrate later, in the absence of any incriminating evidence. So whether my learned friend would want to rely on section 68 or on 69, any whichever section which is coming in chapter 6 he takes, ultimately explanation has to be found satisfactory either by the assessing officer or by the settlement commission. That is his pure subjective satisfaction, which can't be called into question.
In light of the bar of.
Exactly. So therefore, my lords, now I will take my lords to one last aspect before my learned friend may want to argue on, my lords. Section 69. I will take my lords to some 4 or 5 documents. Now, my lords, during search on 15/5/2018, during search on 15/5/2018, a question was asked during search. Question 14, certain questions were asked. My lords may most kindly note the answer there. My lords may kindly go to page 53, last penultimate page. There is a table, and below the table, my lords will notice answer. Page 53, last but one page, my lords. There, if my lords have found that, I'll just read it out, my lords.
Question?
Question 14.
Yes.
And there is a table at the end of that question. I have not received any documents relating to Mrs. Nirav Modi's search. Hence, I'm unable to comment on the documents found in the said search. This will establish, my lords, whatever is so-called found is not even given. Later, my lords, may kindly take the retraction. My lords, will the retraction of this statement on 15/6/2018. This retraction has not been denied. The contents therein have not been denied by the revenue. Para 1, my lords. Proceedings under 132 were initiated against me on March at 9 a.m. Further, the proceedings were continued until March 22, 2 a.m. early morning, my lords, and provisionally concluded on March 22nd. Then, my lords, as my lords would go further down, paragraph 5, I've been informed, paragraph 5, my lords, that have been paid cash of 2.16 crores for the purchase of jewelry. I have not been provided any documents relating to cash payments which are seized from Mrs. Nirav Modi's office. However, after going through the severe pressure, I decided to declare an amount of 2.16 crores on which the department alleged I have paid cash. It is also pertinent to note that there is no material or document found during the course of the search at my residence relating to the alleged cash payment made for the purchase of jewelry. Kindly furnish the copy of the details for evidence to prove that I have paid cash to Nirav Modi. This retraction letter requests the department to furnish the details. Then, my lords, in the very same document, para 11, my lords. Para 11. During the proceedings on May 15, 2018, I have given statement, since the department has not furnished the evidence of payment of cash of 2.16 crores to Nirav Modi, I'm withdrawing the statement declaring amount of 2.16. Then, my lords, para 12 gives the reasons, my lords, that my bank account was at 12.1. From the date of search till partial closure, the department has used all the pressure tactics like delay in opening my bank accounts, continuing the search proceedings for 41 hours without any break, seeking declarations, not providing adequate opportunity to rebut the evidences, and various reasons are cited, my lords, to give this. Subsequently, my lords, may kindly go to my statement of objection at R1C, my lords, which is at page 63, my lords. Lord, this is a rebuttal filed by the respondent SSC before the Settlement Commission in respect of Rule 9 report furnished by the Commissioner, my lords. In this, my lords will notice if my lords were to kindly go to page 65. In fact, my lords, at page 64, my lords, my apologies. In the table, there is one column 5, my lords. Applicant has retracted a statement, my lords, are there. On 15/6/2018, it is submitted that during the course of proceedings, statements that were taken were not voluntary. The fact can be understood through the letter dated 15th June 2018. The brief reasons for retraction are mentioned, which my lords have already read in the retraction letter. And after that, Roman 1 and 2, my lords may kindly go to the next page. It is further submitted that the learned respondent has relied only on the statements recorded from the applicant under 132(4) and has arrived at a finding that the additional income has to be taxed. The applicant would like to draw the kind attention of the Honorable Settlement Commission to CBDT Circular number F286 regarding admission of the undisclosed income during search or survey. In the above mentioned letter, CBDT has clearly instructed the officers to avoid obtaining admission of undisclosed income during the course of search. It is pertinent to note that the applicant has given declaration as additional income. However, nowhere in the statement she accepted to pay taxes under 115 BBE of the Act. It is further noted that no incriminating document found during the course of search relating to purchase of jewelry. The applicant has voluntarily given details of invoice and bank payments relating to purchase of jewelry. During the course of settlement assessment, applicant has sought details of incriminating documents seized during the course of proceedings under 132 in the case of applicant as well as Nirav Modi. In response to our letter, applicant has received a letter dated so-and-so from the Deputy Commissioner, Bangalore, enclosing alleged document found during such proceedings of Nirav Modi. The copy of the same is enclosed. From the above, it can be seen that it is not an incriminating document seized from Nirav Modi's premises. This seems to be a statement prepared by the Income Tax Department. From the above, it can be concluded that there are no incriminating material found during the course of search or any incriminating material brought on record to say that the applicant has paid cash for the purchase of jewelry except applicant's own statement. Now, my lords may kindly go to what revenue itself has furnished. In the same document, my lords may kindly go to page 86. page 86.
If there was no incriminating material found,
Found.
then there ends the matter
Yeah.
under normal.
In fact, the board, my lords, Central Board of Direct Taxes in the circular that is cited, which I'll show my lords, the circular a little later, says to the revenue officials, when you go and conduct the search, focus on unearthing incriminating evidence. Don't focus on merely extracting statement, which will be later on retracted. And the honorable courts have held that addition cannot be made merely on the basis of the statement extracted during search. It is the say of the Income Tax Department. Now, my lords, may most kindly go to page 86 of the very same document. There, my lords, covering letter from the department during the assessment. The copies of the statement recorded during the course of such proceeding in your own case is hereby provided, which my lords have already seen. Then, my lords, next sentence is extremely important. The piece of evidence in relation to the cash paid in purchase of jewelry is hereby provided. This is the piece of evidence. My lords, may kindly go to the next page. And my lords will be astonished to see the piece of evidence, which is nothing but an Excel sheet prepared by Principal DIT Investigation. He writes 13-14, 15-16, 15-16. He will write 3 amounts. He will write what is unaccounted. He will write the PAN number. Then he will write DGIT. How could this ever be called as incriminating evidence? To this, the assessee will object. My lords, may kindly go to the next document, R1E. Next document, my lords, at page 90. The document starts at page 88, my lords, where my lords assessee object to this kind of an evidence. And if my lords were to go to page 94 at para 8, the assessee writes to the department, during the course of such proceedings, are my lords there?
Yes.
And post such inquiry, assessee has sought for incriminating documents relating to Nirav Modi's purchases, which are in the possession of the authorizing officer. However, the same was not furnished. Further, in response to a request dated 5th of August 2019, assessee has received a piece of paper which termed as an evidence in relation to cash paid in purchases of jewelry through letter dated August 22, 2019 from your office. Kindly note that this document does not seem to be incriminating one, as the same seems to be prepared by the Income Tax Department and not found during such proceedings of the assessee or in such a proceeding of Nirav Modi. The document which my lords just little ago saw, the assessee writes, how can this be called as an incriminating evidence? And in the very same document, as my lords will go further down at page 96, para 14.5, we once again pray that we request you to provide the incriminating documents found in the premises of Nirav Modi and also provide the copy of the statement recorded during the course of proceeding. We also request you to arrange for cross-examination of the person who has given the statement. Nothing has been done. No incriminating materials have been given. And on the basis of this, my lords, the Settlement Commission, my lords, writes in Annexure D, in the order, my lords, Annexure D of the petition, Settlement Commission rightly notes that no incriminating evidence has been furnished, my lords.
Page?
I'll take my lords. My lords will find it at para 12.2 at Annexure D. My lords are there. Para 12.2, my lords, at Annexure D. In the petition, my lords will find this. There, my lords, it starts. Department contends that the applicant has not even identified the donors. It further contends that the applicant has not disclosed cash gifts if actually received as cash in hand in the wealth tax returns. The applicant has disclosed income of 2.2 crores represented by cash gifts from non-relatives and friends in the Settlement Commission. She has filed an affidavit in support of the receipt of gifts. She has sourced the cash payment of 2.16 from the cash gifts. No incriminating documents were found during such to show that the applicant made any cash payment for the purchase of jewelry. So therefore, my lords, there is no document at all. In the absence of revenue, if revenue had given any document to the settlement commission or to the assessee, then if the settlement commission unlawfully ignored the same and went on to accept the affidavit of the assessee, then it could have been possibly a case of natural justice not being adhered to, some document not being seen. Finding could have been possibly perverse because an existing document is not seen. There's nothing. In the absence of any of these documents, settlement commission, in the interest of settlement, accepted the affidavit of the assessee. There is no law which says that the affidavit of the assessee should be ignored.
Let me go further.
Yes, my lord.
Now, in case incriminating material was found and the settlement commission still goes to accept.
Yes, yes.
Let's assume
Yes, yes.
that to be the scenario.
Very,
Is
very
it-
pertinent
is it
question.
Still open to be questioned.
It's not, for the reason that settlement commission in its wisdom may say the so-called evidence which is called as incriminating by revenue, in its wisdom and opinion, not incriminating. My lords may have seen various decisions, but certain loose sheets which are found. Questions are raised, are they incriminating? This Honorable High Court, my lords, and Sunil Kumar Sharma, the Honorable Division Bench, in 2023, my lords, has held that the loose sheets cannot be called as incriminating evidence at all. So I'm just giving an illustration, my lords, where what is called as incriminating by one party need not be accepted to be incriminating by the settlement commission. Settlement commission may still go on to say that it is no more incriminating. But only point is, if the so-called incriminating evidence furnished is not even adverted to by the settlement commission, then it may be a case of intervention because
Now, that has been considered here.
exactly. That I may put it this way. So therefore, my most humble submission, my lord, says the stake involved is small. Revenue cannot be a compulsory litigant. Settlement commission's orders are not ordinarily questionable. And section 69, my lords, will give discretion even to the assessing officer. Now, my lords, let us assume that I am not before the settlement commission. I am before the assessing officer for a while, my lords. Only on the basis of this piece of paper could the assessing officer have made an addition. I will take, my lords, the board circular in this regard. My lords, may kindly take my compilation, my lords. Page 97, my lords. My lords, may kindly take my statement of objections, my lords. Sorry. In my statement of objection, my lords, annexure R1, F, my lords. This was what was referred to, my lords, in assessee's objection to Rule 9 statement before this settlement commission. Lords, I may be permitted to read this, my lords. Instances have come to the notice of the board where assessees have claimed that they have been forced to confess the undisclosed income during the course of search and seizure and survey operations. Such confessions, if not based upon credible evidence, are later retracted by the concerned assessees while filing returns of income. In these circumstances, such confessions during the course of search and seizure and survey operations do not serve any useful purpose. Lords may most kindly appreciate. Even for the purpose of 68, 69, it will not serve any useful purpose. It is therefore advised that there should be focus and concentration on collection of evidence of income, which leads to information on what has not been disclosed or is not likely to be disclosed before the income tax department. Similarly, while recording statement during course of search and seizure and survey operations, no attempt should be made to obtain confession as to the undisclosed income. Any action on the contrary will be viewed adversely. This was followed by, my lords, one more circular in the very next page, page 98, much later in 2014. There, my lords, instances stroke complaints of undue influence and coercion have come to the notice of CBDT and some assessees were coerced to admit undisclosed income during the searches and surveys conducted by department. It is also seen that many such admissions are retracted in the subsequent proceedings since the same are not backed by credible evidence. Such actions defeat the very purposes of search and survey operations as they fail to bring undisclosed income to tax in a sustainable manner, leave alone levy of penalty or launching prosecution. Further, such actions show department as whole and officers concerned in the poor light. I am further directed to invite your attention to so and so to focus on gathering evidences during such stroke survey and to strictly avoid obtaining admission of undisclosed income under coercion and undue influence. Therefore, my lords, the board itself is saying that addition is, my lords, board being at the helm of affairs from the tax gatherer's end, it's itself saying in the absence of incriminating evidence, no addition could be made. My humble submission is, even if it were the assessing officer who were to do it, it is immensely an arguable case that no addition could have been made on the basis of this type of an evidence. If it were so, my lords, what is wrong in settlement commission accepting it? Therefore, my lords, this petition deserves dismissal in limine, my lords. And in case my learned friend wants to argue on merit, my lords, I may be permitted to report.
When will you continue? Tomorrow? Tomorrow or next week? When do you want? Tuesday. That is on 19th, we'll have it on Wednesday. Because Monday. Relist the matter for further hearing.
Lords, on Wednesday, my lords? Wednesday.
2:30 on 19th.
Yes. Obliged, my lords.
My lord, serial number 81. It's a covered matter. A date may kindly be fixed, my lord. 81, my lord.
Relist the matter. It's covered squarely or any arguments?
Squarely, my lord. It is covered squarely, my lord. It may be disposed also in the next date of hearing.
Preliminary hearing list. You file a memo for disposal. I'll order a preliminary hearing. File a memo for disposal. You get it countersigned by the other side. So that they know what is the point on which you're saying it's covered. So in that memo, you just one-page memo and say it's covered by this, get it countersigned so they are aware of it.
Please.
My lord, serial number 66, my lord. I have filed, it's a fresh matter. I need to be heard on the interim order. My lord, I have filed an application under 6 Rule 17 for amendment of petition. If it is listed in under orders, it will reach, my lord. There is urgency in the matter. 66, my lord.
List the matter in the orders list on
My lord, a short accommodation.
19th.
My lord, on 20th or 18th, my lord. 18th or 20th, my lord.
25th.
18th, my lord.
18th is
My
education.
lord, 19 may be taken up, my lord.
19th.
Urgency. I'll accommodate.
My lord,
Obliged.
serial number 47, my lord. It's for further preliminary hearing.
47.
Passed over that. Tomorrow or day after tomorrow.
Relist the matter on. Huh? 24th.
My lord, respondents issued attachment notice here, my lord. Tomorrow or day after tomorrow.
You take your chance on 14th. It reaches, it reaches.
46. 46, 46.6, my lord, participate passed over. In fact, the name of my lord's learned counsel, MP Srikanth, is not shown, my lords, as appearing for
Office to
respondent.
show the name of learned counsel. MP Srikanth as representing respondent number.
2, my lords, in 46.6
Relist the matter tomorrow.
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 Great. 88, your lordship, 2:30. Must contain tomorrow or any day.
Yeah. Okay.
18th, your lordship, 2:30.
19th.
Because the other matter also is there on 19th, your lordship. Because there's one more matter, your lordship, my lords are given me on 19th at 2:30.
We'll have it on 25th.
Tomorrow, day after.
Tomorrow's company day, day after tomorrow, division bench in the afternoon. Let it be in the list on 19th, let us see. 19th.
Great.
Sir, serial number 79. Sir, serial number 79 on to date Cody.